Yes, Your Lordship. Lordship, I may kindly be allowed to mention item number 5, Lordship. Lordship, here we are yet to file affidavit in reply, so kindly grant me 2 weeks time, Lordship.
2024 matter. When did they file the affidavit?
Lordship,
Affidavit in opposition, when did they file?
it has been 3 weeks.
Then, as per the High Court rules, you have to file within 7 days.
Lordship, last and final chance, Lordship.
Last and final chance, we'll see when the matter reaches.
Lordship, Lordship, I beg to mention item number 15. Lordship, can you grant 3 weeks time to file affidavit?
We'll see when the matter reaches.
Your Lordship's permission, my lord.
Yes.
With your Lordship's permission, item number 14, my lord.
14.
14, my lord. 14.
Yes.
I need to file a reply, my lord. The party, authorized signatories are traveling abroad, so I could not file it. Your Lordship may give 2 weeks time, my lord, finally.
There's no interim order, I suppose.
No, my lord, no interim order.
We'll see when the matter is reached, I'll pass an order. Okay? Ask your junior counsel to.
Obla. Obla.
For motion, item number 1.
May I please receive? The council is going to appear to VC and he has some problem with the internet connection.
Internet, there are so many councils out here who is appearing.
On his instruction, I pray for a short passover. He's going.
What is the matter about?
We are praying for a investigation. As the insurance company, there are some rules to be complied. There was no a postmortem over the dead body.
No, we issue a notice. Let's see. Let's issue a notice. Issue notice making it returnable on 11th of May 2026. Ms. So-and-so accepts notice on behalf of the respondent numbers 1, 2, 3. Extra copies of the petition be served upon her by the course of the day. As regards the respondent number 4 and 5, the petitioner is directed to take steps by way of speed post by tomorrow. It is the case of the petitioner herein that the investigations so carried out pertaining to the submission of the death claim under policy numbers U2047861117 have not been done properly. And as such, the petitioner herein had submitted a detailed representation to the additional superintendent of police herein, requesting re-investigation of herein PS case number 0001/2025. It is on account of the inaction on the part of the respondent authorities. How can you ask for re-investigation?
That's what, Your Lordship.
You cannot ask for a investigation under 226.
My lord, I have some judgment which allows for the reinvestigation if
There may be a case of further investigation. There cannot be a case of reinvestigation. Where is the judgment which says the reinvestigation?
my lord, yeah, but if we also if you want this to hear that.
For reinvestigation of Heron PS case number 0001/2025. As the representation remained as the representation was not considered, the petitioner has approached this court. Ms. Esmeri, the learned counsel appearing on behalf of the state respondent, submits that the concept of reinvestigation is foreign to the Code of Criminal Procedure 1973, or even the BNNS, full form you put it, 2023. 23, 25.
Yes, Your Lordship.
Pusto. She therefore submits that the instant writ petition is not maintainable. Pusto. The respondents are directed to bring on record their stand by filing the affidavits. Pusto. Though this court had issued notice, the maintainability of the writ petition is kept open.
For motion from the supplementary course list, item number 26.
It is Your Lordship.
What is this?
Your Lordship, I am filing this writ petition for challenging the order passed by the NIC against the order dated 18/2/26, Your Lordship.
Where is the order?
The order has been annexed as Annexure A in page 12 of my petition, Your Lordship. It is not very clear, so I have
Page?
page 12, sorry, page 12, Annexure A. The order is not very clear, so Your Lordship, I have given a type copy in page 17.
Yes, what is wrong with this order?
Your Lordship, to begin from the
What is
beginning.
the information you sought for?
Yes, Your Honor, the information I sought was as simple as whether the notice inviting tender was published in the newspaper or not. Just yes or no reply, Your Lordship. That was not supplied to me. Instead,
So here it says in the decision
yes, Your Lordship.
that since a copy of the NIT and the photograph of the NIT displayed in the department notice have already been furnished to the applicant now, appellant, that sufficient explanation and clarification regarding the NIT has already been given by the public authority to dispose of the case. However, the public is advised to advertise for open tendering of all works wherever there is a provision for so and so.
Your Lordship, my question was whether it was published in a notice board or not. Now, my question was not that, Your Lordship. My question was whether it was published in the local dailies or not. A simple yes or no could suffice, no explanation needed.
Madam, kindly come to page 27.
Yes, Your Lordship.
Furnish the true copy of the notice inviting tender published in the local/national dailies for the work establishment of college of so and so construction at so and so.
Yes, Your Lordship.
So you have asked only for the notice inviting tender.
Yes, whether it was published in
Where
local
is the
dailies.
where is the word whether?
Yes, Your Lordship, but it was only a yes or no could have sufficed, no explanation
No,
needed.
it's not a question of it. You say that you want a notice inviting tender. They say that this is the notice inviting tender.
Yes, Your Lordship, that
But
is
the
also
fact-
there, Your
But
Lordship.
the answer therein makes it very clear that there is nothing out there, that it was not published in the newspaper.
Yes, Your Lordship.
When they are mentioning, because what they have asked is, it has already been furnished to the applicant.
Yes, Your Lordship.
Now here, they have done it or not, if you had put that question, whether you published it or not, that would have been a different answer. That is not done.
Yes, Your Lordship.
You go ahead and ask if you want to. But what is the wrong with this order? In fact, the order is self-explanatory to say that actually you have not carried out.
Your Lordship, if we see from the inception of RTI being filed, a very lenient view has been taken by the public or this NIC to the public authorities.
No, understood. Lenient view is for us to take a very strong view.
Yes, Your Lordship,
So
I
you
understand.
come-
Very
no,
based, but very based,
Madam,
Your
you
Lordship.
then come over to us and file a writ petition that they have done this work without notice inviting tender, being published, advertised. We can take a very strong view. But the Right to Information Act, in fact, what has been mentioned here in the other portion of the decision is outside the purview of the NIC. The NIC or whatever these authorities under the PIO is only to provide the information. They are not going to require to give suggestions.
Yes, Your Lordship.
So they have given a suggestion. You are appearing for whom?
I am appearing for the petitioner, Your
Now the
Lordship.
petitioner whom? Means the applicant.
Yes, 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 the applicant of the RTI,
Here
Your
they have
Lordship.
given you more than what is necessary.
That was not required. No explanation was needed.
So if they given an
Not needed,
explanation-
actually, not needed.
Not needed, but they have given you an explanation. You should
Yes,
be
Your
more happy.
Lordship.
You should be more.
But my contention, Your Lordship, is from the very beginning of this RTI, they have been giving a very based and lenient view to the public authorities. See, Your Lordship, there has been delay also, but there also a lenient view has
You
been
do one thing.
taken off.
If you want that answer specifically, put a question that this is the notice inviting tender which you have given it to me.
Yes, Your
Did you
Lordship.
put it in the newspaper?
That being one of my ground, Your Lordship, another ground is
That
there.
is
Yes.
the only ground you have to ask them. Go and ask him. He'll get an answer. Why should we go ahead into this thing and asking them to set aside this order makes no sense. You asked, kindly furnish the true copy of the notice inviting tender. They gave it to you.
Yes, Your Lordship. That one of my ground is there.
Your
However,
question is-
another
your
ground is
question
also
is-
there, Your Lordship.
Give me the notice inviting tender which you published in the newspaper.
Yes, Your Lordship.
They gave you a notice inviting tender. So go and ask properly now. So close it.
Some few other grounds are there for setting aside this order, Your
Why
Lordship.
should we? Your simple prayer out there in your right to information application is that kindly provide me a copy of the notice inviting tender which you have published in the local dailies. You never asked that, did you publish in the
Yes, Your
local daily?
Lordship, I get it.
So therefore, you withdraw this with liberty to seek that answer if you want. Or otherwise, makes it very clear.
Your Lordship, one of my ground also kindly hear me out, Your Lordship.
Yes, please.
Delay by the departments that have been also condoned without any specific reasons. See, Your Lordship, I have been filing my RTI from 13 May 2025.
But madam, did you file an application under section 20?
Yes, Your Lordship, I went to the process of filing my first appeal, second appeal. I have been filing consistently, Your Lordship.
20 is penalties.
Yes, yes, yes,
Did
Your
you file an
Lordship.
application for penalties?
Yes, Your Lordship.
Where? Where's your application for penalties?
In my first appeal, Your Lordship.
Very good.
In my second appeal to the commission. In my prayer of point number 3.
Madam, you tell me one thing. Kindly come to page 27.
Yes,
Okay.
Your Lordship.
27, you have asked this information.
Yes, Your Lordship.
Okay. Kindly come to page 36, the appeal.
Yes, Your
Here
Lordship.
you are asking more information. Why?
Arising out of the previous,
Understood.
yes,
How can
previous
you-
RTIs.
This is an appeal. Can you ask something which is not there in the initial one?
Yes, Your Lordship. We understand that. However, this RTI has been dragging on from the time of 13/5, Your Lordship. That's what I wanted to explain.
Understood. It is understood, but you have asked for what they have given you the copy.
Yes, Your Lordship.
Because you say that you don't want this copy, you want the copy which is published in the newspaper. There it is also made.
Because they
clear.
were not giving the straight answer of yes or no, Your Lordship.
So then file a writ petition. If you are aggrieved out there, file a writ petition that you are a person who is aggrieved. You would have participated in the contract had they published in the newspaper and come before this court. We are always waiting. But proceeding with this makes no sense.
Yes, considering my section 20 also, Your Lordship, I've given my second appeal of point number 3 in my prayer, stating that the commission might
No, madam, what you are asking
give
is
penalties,
every
Your
time you
Lordship.
are asking for more. What are these? Information sought. Second RTI on 18. These are different.
We wanted
RTI
the commission to have a clear view of our inception of RTIs that has been denying from the beginning, Your Lordship. So we have annexed the first RTI starting from 13. They have been passing from one
But
another
those
without giving us
But,
information, Your
but
Lordship.
madam, those RTIs are not a part of the writ petition.
It's there, Your Lordship.
No. At only page 27 is that application. The other persons are not there. Seeking information 19.6. Furnished.
Yes, Your Lordship. The initial RTIs are not being annexed because, Your Lordship, the only concern that we approached the second appeal was that of RTI dated 19/6.
Then
However, to make a clear view, to make the commission understand from the inception, we have annexed all the RTIs from the beginning.
can't help you, madam. You file it properly. Ask them, then come over. We dismiss it.
Please give an opportunity, Your Lordship.
For what? I am giving you the opportunity. Go there and file another one asking the specific thing. You hear that order, what I am passing. Heard Mr. So-and-so, the counsel appearing on behalf of the petitioner. And Mr. So-and-so who appears on behalf of all the respondents?
No, 1, 3, and 5.
1, 3, and 5. Pusto. Taking into account the issue involved herein, this court takes up this matter, the writ petition for disposal at the stage of motion. The petitioner herein had filed an application under the Right to Information Act 2005 on 13/5/2025, seeking a copy of the notice inviting tender published in the local/national dailies for the work establishment of the College of Nursing correlated with the college, bracket NIMSR, bracket close, construction of the administrative block at NIMSR. Full stop. The petitioner did not receive any information which led the petitioner seek and file another application on 19/6/2025 seeking the same information. As the petitioner then also did not receive an information, the petitioner filed a first appeal. Further to that, as information was not divulged, then also the petitioner filed a second appeal. Second appeal before the Nagaland Information Commission. The Information Commission, the Nagaland Information Commission, by an order dated 18/2/2026, after noting down the facts, disposed of the said appeal, observing that a copy of the NIT and the photograph of the said NIT displayed in the department's notice board have already been furnished to the petitioner, and that sufficient explanation and clarification regarding the NIT had already been given by the public authority. First, the petitioner, however, is aggrieved by the fact that the answer, that the query which was asked for by the petitioner as to whether there was an advertisement, whether the notice inviting tender was advertised in the local dailies as well as national dailies, have not been answered by the concerned respondent authorities. This court have duly taken note of the application which has been filed on 13 applications which were filed on 13/5/2025 and 19/6/2025. And from the said, it appears that the petitioner only sought for the notice inviting tender published in the local/national dailies for the work establishment of the College of Nursing correlated with the college NIMSR, construction of the administrative block at NIMSR, Kohima. And in that regard, the respondent authorities have provided the notice inviting tender, a copy of the notice inviting tender, as well as the photograph of the said notice inviting tender published in the department notice board. First, taking into account the query which the petitioner had, the information which the petitioner had sought for, and what has already been provided to the petitioner, this court is not inclined to exercise its jurisdiction under Article 2 to 6 of the Constitution. However, accordingly, the instant writ petition therefore stands dismissed. Be that as it may, and before parting with the record, this court, however, observes that the dismissal of the instant writ petition shall not preclude the petitioner to seek information specifically on the question as to whether the notice inviting tender, which was displayed in the department's notice board, was published in the local dailies/national dailies if so advised. Now ask them.
Much.
Much of that.
For admission, item number 2.
What is this?
May I please, Your Lordship? Your Lordship, I'm instructed that the senior counsel for the petitioner could not attend to the duty under medical circumstances, as his close relative of his passed away last night.
So you have no urgency.
Your Lordship, I'm instructed that the matter be listed on either Thursday or Friday.
It seems so the instant writ petition was listed on 16/3/2026. And today the matter has been fixed on for admission hearing. However, the counsel appearing on behalf of the petitioner seeks for an accommodation. It therefore appears that the counsel, that the petitioner has no doesn't have an urgency in the instant proceedings. Accordingly, the instant writ petition stands adjourned to be listed only when the counsel for the petitioner seeks for approaches the registry with an application. Full stop. The interim order passed earlier shall continue till the disposal of the writ petition.
For admission, item number
Nominee
3.
appears for the state. Yes. Oh, yes, Mr. Counsel. Mr. Counsel, tell me one thing. Without any challenge to the advertisement, how can you challenge his appointment who has been done purely on merit?
Actually, the Lordship,
There's no quarrel.
yes,
You have a right on the question of land ownership. That is a different right,
my lord,
which needs to be considered as per Rule 3B.
my lord.
That will be considered by them. But the fact remains that this person concerned was appointed on the basis of an advertisement. Now you have not challenged the advertisement. How are you going to, and why you are picking up and choosing only one person when that advertisement had the appointment for 3? It was not that this advertisement only specifically mentioned about this post. This person concerned, the respondent concerned, the private respondent concerned who was appointed on the basis that this person concerned is one of the 3 who have been selected.
My lord, the fact was that the respondent number 5, she was appointed on the post where I applied before the advertisement.
Yes.
Yes, that is the,
Understood. But without challenging the advertisement, that you cannot go for an advertisement of this post because this post is specifically reserved for land ownership. How do you maintain your reputation? That is why my question is. That day I wanted to
Yes,
dismiss,
yes.
but he said that his senior will be there to explain it to this court as to how is it possible that without challenging the advertisement, because then you see, you are picking and choosing only one. It may have been that the respondent number 5 would have been appointed in the other 2. And there would have been another person who would have been the respondent number 5.
my lord.
The fact that he had been only appointed against that post, you are challenging that.
Yes.
But
Since-
you have to challenge not only that appointment, you have to challenge the advertisement that this post would not have been put out there. But where is the power right of yours to challenge the advertisement also?
My lord, the actual fact is that where the office is located and where the petitioner applied for the post, it is situated on the land donated by the grandfather of the petitioner. So my right arises since there was a vacancy in that office. So I applied prior to the advancement and it was under process.
Understood.
Yes.
All understood. You may have a better right to be appointed, but that post was kept and selected on a basis of a selection. And it was therefore these people were appointed.
My lord, another aspect is also there. In the affidavit of the respondent authority, they have stated that landowners from our family, some were appointed. Now, their appointment concerned. One is appointed on contingency basis. Contingency basis, not on the regular basis. And not on the basis of landowner.
No,
That aspect.
no, Mr. Counsel, in that respect,
Yes.
I also told your junior who was insisting, your right to be considered under 3B shall be again reconsidered as per law, as to whether you are entitled. And when there is a vacancy out there, as he has a right, you have a right that will be considered and you will be taken care. But this, how can you challenge him?
So, my lord,
That is the only way I am thinking that your right as regards as to whether you had an oral agreement, all these things has to be looked into. There is a question as to anybody else have been appointed, because an appointment on land ownership basis cannot be contingency.
Money.
It has to be against the post.
Regular.
It has to be a post of the state.
Money.
So that post, I think Group C or Group D, no? Well, what post? Group 4.
Group four.
Group 4, it is to be only on Group 4. So that post has to be there. But whenever a vacancy arises, you will be considered in terms with that notification. You are entitled to that. Because that also, that post has to be there. But these person, you cannot do it unless there is a challenge to his advertisement. Advertisement not in a sense that you could not have advertised this post. That has to be a challenge to that.
My lord, the
You see, the
petitioner was,
problem arises, that is why I
yeah,
speak.
petitioner was also not aware of the advertisement. That is, petitioner was not aware of the advertisement. Because it was to be challenged before the interview was held. But he was not aware of that.
Understood, but he has been appointed. When he filed the writ petition, he knew that this appointment is on the basis of an advertisement.
He was not aware, except after
No,
receiving the.
at the time of filing of the writ petition, he was aware.
No, my lord, no. Only after receiving the evident opposition of the respondents, he came to know. Otherwise, he was not aware.
So then we do one thing. We dispose of the writ petition with a direction that as regards their appointment, we are not touching it, as there is no challenge to that. But however, you will be considered as per the notification of 5.3 and whenever a vacancy arises. I think that would be, it could help the petitioner. Yes. Heard Mr. Your name, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Ms. So-and-so who appears on behalf of the state respondent, and Mr. So-and-so who appears for the respondent number 5.
Yes, sir.
The petitioner herein has approached this court for setting aside the approval, setting aside the letter dated 29/11/2023, communicating the approval for appointment of the private respondent number 5 issued by the Office of the Commissioner Nagaland. And further, the notification dated 12/12/2023, whereby the private respondent number 5 was appointed by the Deputy Commissioner, Kifri. The petitioner have also sought for a direction to appoint the petitioner against the vacant post of grade 4 multitasking staff in terms with the policy of the government of Nagaland for granting appointment on land ownership basis. The brief facts which led to the filing of the instant writ petition are that the Office of the Extra Assistant Commissioner, Sitmi Circle Headquarter, Kifri, was established in the year 1972 and standing and functioning over the land donated by the grandfather of the petitioner.
Yes.
It is mentioned in the writ petition that there was a written agreement and oral assurance of the respondent authorities that the petitioner, that the family of the petitioner would be granted an appointment in lieu of the land being donated.
Yes.
The petitioner submitted an application in the month of April 2023 for appointment to the post of grade 4 on the ground of land ownership basis against the post of peon lying vacant under the establishment of the Office of the Extra Assistant Commissioner, SITMI, on the retirement of Sri Litsamong on superannuation on 31/10/8/2020. The said application of the petitioner was accompanied by the recommendation of the member of the Legislative Assembly and a no objection from the head Gambura of Sitmi village. The petitioner was called for an interview on 22/9/2023 in the office of the Deputy Commissioner Khifri. It is alleged by the petitioner that without considering the case of the petitioner, the Commissioner Government of Nagaland approved the appointment of the private respondent number 5 against the vacant post of peon, grade 4, multitasking staff in the office of the EAC, Sitmi, and communicated its approval to the Deputy Commissioner Khifri by letter dated 29/11/2023, even though the respondent number 5 was not a landowner. Mr. Counsel, take a seat.
Yes.
It is the further case of the petitioner that pursuant thereto, the Deputy Commissioner Khifre, by notification dated 12/12/2023, appointed the private respondent number 5 as multitasking staff, grade 4 post in the Deputy Commissioner's office under the District Administration Department against the post lying vacant on the retirement of Sri Litsamong Sangtam on 31/8/2020. The petitioner thereupon, being agreed, had approached this court by filing the writ petition on 19/2/2024. The record reveals that this court, by an order dated 22/2/2024, issued notice and observed that the writ petition, that the appointment of the respondent number 5 shall be subject to the outcome of the writ petition. The record reveals that the respondent number one, two, 3, and 4 had jointly filed an affidavit in opposition through the additional commissioner in the department of the Commissioner Nagaland. It was mentioned that Sri Jung Zuzhozhe, the grandfather of the petitioner, was one of the landowners of the site where the EAC office Sitmi stands. However, the land, as per the verification report dated 9/4/2024 by the Dobasis, is a common family land of late Haviki, Havikhe, and his descendants. It was further mentioned that a detailed report of the extra assistant commissioner, Chiosum, dated 25/6/2022, was obtained pertaining to the status of employment of landowners of Sitmi headquarters, and it indicated that 2 landowners have already been employed by the government. It was also mentioned that the petitioner cannot claim another appointment on land ownership basis in perpetuity, violating the government's notification dated 5/3/2018. It was also mentioned that Sri Jughoji was one of the signatories of the 1972 agreement, wherein it was mentioned that the land donated was a part of the family's common property. It was also, in addition to that, it is also stated that the letter of the extra assistant commissioner, SITMI, dated 17/5/2006, reveals that the land housing GA quarters and the EAC office at SITMI belongs to Sri Juguji and his brothers. It also mentioned that one Sri Ahisi, Aheshe, and Srimati A. Hosile Sumi were appointed as Dakrana and Mali respectively, based on their ownership at the land. The affidavit filed by the respondent number 5, however, is of relevance inasmuch as it appears therefrom that in respect to 3 posts, you should have got your magnifying glass. That day also I said, very difficult to read. In respect to 3 posts, an advertisement was issued on 9/8/2023 by the Office of the Deputy Commissioner Kifri. In pursuance to the said advertisement, a selection was held and the respondent number 5 along with 2 others were selected. It is further mentioned that in pursuance to that, the respondent number 5 was appointed. In the said affidavit filed by the respondent number 5, further details have been provided as regards the right of the petitioner to claim appointment on land ownership basis. And it was mentioned that there were 2 persons who have been appointed on land ownership basis under the Extra Assistant Commissioner's Office, SITMI. One was Sri Ahisi, who was appointed as a Dakrana on 8/8/2013. And was permanently absorbed in the services of the state. Whereas Srimati A. Hosile Sumi was appointed as a Mali on 14/1/2004 on contingency basis. The orders of appointment of Sri Ahisi as well as Sri or Srimati? Huh? Are you sure? Srimati A. Hosili Sumi have also been enclosed to the said affidavit filed by the respondent number 5. The record reveals that the petitioner had filed affidavit in opposition, affidavit in replies. Wherein the petitioner denied that Sri Ahisi was appointed as Dakrana on regular basis on the basis that Sri Ahisi's appointment as Dakrana was not denied, that Sri Ahisi's appointment as Dakrana was on the basis of ownership. Further to that, as regards the appointment of Srimati so-and-so, it is mentioned that the petitioner, that the said person was only appointed on contingency basis, which is not in terms with the office memorandum dated 5/3/2018. The records reveal that a rejoinder affidavit was filed by the respondent numbers 1, 2, 3, and 4. Wherein, at paragraph number 5, it was mentioned that 3 individuals were appointed from the landowner's family on land ownership basis, namely Sri Hevito, appointed as Dobasi by order dated 30/5/2003, Sri Ahisi as Dakrana, and Srimati A. Hosili appointed as Mali. It was also mentioned that the father of the petitioner, Sri Isaac Sumi, was awarded a contract for construction of the EAC Sitmi headquarters. Sri Hevito is the brother of Sri Isaac Sumi. And therefore, the petitioner was not entitled to be appointed on land ownership basis. The family tree of Sri Jugoji now, it was also mentioned that there was no conclusive evidence proving that the land donated for the EAC office was exclusively contributed by Sri Juguji, and it does not specify the precise portion of the land contributed by each donor. The agreement dated 14/2/1972, listing the 12 land donors, including Sri Juguji, as one of the signatories. However, as per verification report dated 9/4/2024, report dated 25/6/2022, and the letter dated 17/5/2006 shows that the donated land was a part of the common family property. It is also mentioned, it was denied that no descendants of Sri Jugovji was appointed till date as per the family tree verified by the administrative officers. Multiple members of Sri Jugovji family have been appointed on the basis of land ownership. It was also contended that the appointment on land ownership basis cannot be on the basis of perpetuity. This court have heard the learned counsels appearing on behalf of the parties and have given who have made submissions in terms with their respective pleadings. Two questions arises in the instant proceedings. First, as to whether the petitioner who claims appointment on land ownership basis can challenge the appointment of the respondent number 5 without challenging the very advertisement on the basis of which a regular selection process was initiated. And the respondent number 5, along with 2 others, were selected. The second question which arises is as to whether the petitioner can claim a right of ownership, or claim a right for appointment on land ownership basis against the post which fell vacant in the office of basis. In respect to the post which is now, wherein the respondent number 5 presently have been appointed. This court have perused the office memorandum dated 5/3/2018. From a perusal of the said office memorandum, it transpires that appointment on the basis of law that it is the policy of the state of Nagaland to honor the written agreements as well as oral agreements prior to 26/7/2005, whereby land have been donated and there is a promise made for appointment to the family of the person who have donated the land. It is very pertinent to mention that appointment to a post, to a public post, public office has to be done in consonance with Article 14 and 16 of the Constitution. However, appointment on land ownership basis, or for that matter, appointment on compassionate basis, are based upon policies of the government. In the case of land ownership basis, as stated above, the policy of the government being to honor the written agreements or oral agreements where there is a promise made by the officials of the state to grant appointment to the family members of the donor in lieu of any compensation paid. In the case of compassionate appointment, it is the policy of the government to provide an employment to a member of the family to override the hardships faced on account of the untimely demise of the sole breadwinner of the family. Under such circumstances, both the appointments made on land ownership basis or compassionate appointment or on compassionate grounds cannot be said to be a mode of recruitment, or to be a source of recruitment. This differentiation and source of recruitment, rather, it's an exception to Article 14 and 16 of the Constitution. The above the aforesaid aspect is of relevance in deciding the present dispute, inasmuch as the petitioner herein claims appointment on land ownership basis, whereas the respondent number 5 have been appointed in the usual course of selection, that is, by way of a process of recruitment. It is not the case of the petitioner herein. That a post wherein the respondent number 5 was appointed could not have been advertised, as it was solely reserved for land ownership basis. Under such circumstances, as the claim of the petitioner is completely different from the claim of the respondent number 5, the claim of the petitioner is completely different from the right which has flown to the respondent number 5 on the basis of the appointment. The instant writ petition, as it stands, would not be the instant writ petition. By way of the instant writ petition, the petitioner herein cannot assail the appointment of the respondent number 5. Next. The second question which arises in the instant proceedings is as to whether the petitioner herein is at all entitled to appointment on land ownership basis. The petitioner herein claims that no member of his family have been appointed on land ownership basis. However, the same have been denied by the respondent authorities. As would be apparent from the pleadings as discussed herein above. This court finds it very pertinent to take note of the notification dated 5/3/2018, wherein the government of Nagaland have endorsed, have cast an obligation upon the Deputy Commissioner to decide as regards the entitlement to be appointed on land ownership basis. The same is done the said fact finding is to be carried out by the Deputy Commissioner on the basis of written statements of the witnesses and other materials which would be placed. On the basis of the pleadings in the instant writ petition, wherein the petitioner herein claims that he is entitled, whereas the respondents herein have denied to the same. This factual adjudication cannot be done by this court under Article 2 to 6 of the Constitution. It is also the opinion of this court that as appointment on land ownership basis is a policy of the government, wherein the policy of the government it would be in the interest of administrative convenience that when there is a claim raised for appointment on land ownership basis, the said claim be decided by the concerned Deputy Commissioner in terms with clauses 3A, 3B, and 3C of the notification dated 5/3/2018. Irrespective of as to whether a vacancy has arisen, inasmuch as when a vacancy arises, it need not be, the authorities need not await for such decision, such adjudication to be carried out subsequently. Considering the above, this court therefore disposes of the instant writ petition with the following observations and directions. First, the challenge made in the instant writ petition to the appointment of the respondent number 5, to the approval of the respondent number 5, to the letter dated 29/11/2023, whereby the appointment of the respondent number 5 was approved, as well as the challenge made to the notification dated 12/12/2023, whereby the private respondent number 5 was appointed, are rejected. Number 2. The respondent authorities, more particularly, the respondent number 3, is directed to decide as to whether the petitioners herein, the petitioners claim to be appointed on land ownership basis has legs to stand in terms with the office notification dated 5/3/2018. The petitioner is given the liberty to provide evidence in the form of written statement of witnesses as well as other documents before the respondent number 3. And the respondent number 3 thereupon shall decide the same and bring it to the attention of the concerned authorities. This court further observes and directs that in the circumstance the respondent number 3 decides that the petitioner herein has a good claim for appointment on land ownership basis, the concerned authorities shall duly take effective steps for consideration of the case of the petitioner for appointment on land ownership basis as and when a vacancy arises in the EAC, in the office of the EAC, Sydney Circle, Kifri.
For admission, item number 4.
May I please, Your Lordship? I'm appearing for respondent number 3, 4, and 5. Lordship, I am filing my additional reply to the additional affidavit filed by the petitioner.
You filed it.
Lordship, this which is under preparation. 2 weeks' time may be granted to obtain the signature and file the.
Yes, what is your case, madam?
Your Lordship, the petitioner is seeking for compassionate appointment.
Compassionate appointment.
Yes.
What is his serial number?
Lordship, he comes under serial number 6, but the matter is that she is seeking for the compassionate appointment to a post which comes under the central scheme, where there is no such provision as such.
Why are you asking for central scheme?
However, the post has been forwarded to the government for observing under the government, state government, which is pending before the cabinet. And that is how we have maintained the seniority list also, Lordship, wherein the petitioner comes under seal number 6. If at all prospect, but if at all observed, then seal number 6.
So you'll be considered when the 6 comes. You cannot be given out of turn. Because in view of the addendum dated 9/4/2019, you cannot be given an out of turn. You'll be considered. You are at serial number 6.
Lordship.
We dispose it of.
Your Lordship,
I passed many orders in that regard. What is there? You don't want any consideration.
Your Lordship, a direction may be given to the state respondent to
Definitely.
as per
As per,
Mm.
as per.
Provided the state also observe lordship, otherwise the respondent don't have the capacity to accommodate. The
What?
matter is pending before the cabinet.
State for what? No, tell
This-
me.
this the
My
post-
question is, the petitioner's father was where? He was working as what?
Under the Department of Social
Petitioner
Welfare.
and his sister was completely around the deceased mother. She was working in Government of Nagaland Department of Economics and Statistics.
No, social welfare.
Office of the Directorate of Social Society in Nagaland, the petitioner's mother, Asra, was appointed as typist and posted at Pansang under the establishment of Directorate so and so.
Social Welfare Department.
Yeah.
Lordship, but the
Social
post-
welfare does not fall within the ambit of the state.
No, but the Social Welfare Department, Lordship, if I'm allowed to mention, the Social Welfare Department have the state post as well as the schemes like the ICTs and all, that is from the central Lordship. And the petitioner was appointed, although that comes under the.
But why
Social
have you
Welfare
put
Department.
her under serial number 6?
Lordship, with the proposal being sent to the state government because the central government has stopped funding for these posts.
So
It's
she
pre
was
and
under
post.
a scheme post.
Scheme post, Lordship.
Let us see her appointment order. You see, Director, consequent of approval of the government and as per the
Next
candidate
one.
acceptance of the terms and conditions, the following so and so is hereby temporarily in the post of LDA typist. Establishment of the Directorate of Social Security and Welfare in the pay scale of so and so and so and so is subject to the following. The appointment is purely temporary. Then
Lordship, the appointment is made against co-terminus post.
where?
Annexure 1, page number 10. The appointment order. Conditions are the
No. Here, thereafter, madam, after that, has she become permanent or not? Because you see, it's the notification of 17 categorically mentions that the post has to be permanent. It's given, na? Appointment shall be on, you say, appointment on compassionate grounds shall be made only on a regular basis to direct recruitment post, and if the regular vacancy meant for that purpose are available in the department so and so. Supersession of AI is to so and so appointment going to be given to one of the following members, compared to be made on following on here, the ceiling for appointment here. So let's say then the scheme will be available to the family of the deceased provided no surviving members of so and so is so and so. See, the scheme will be applicable only to dependents of deceased government servants appointed and serving on regular basis.
Lordship.
This is number 6.
Lordship.
Then, where is her regular appointment?
Your Lordship, the counter affidavit filed by respondent number 2 in paragraph 4. It has been clearly stated that with regard to the statement made in paragraph 6 of the writ petition, the answering deponent begs to state that as per the scheme for compassionate appointment,
Respond number?
there's
Respond number 345.
no, Your Lordship, counter affidavit of respondent 2.
2 or 345.
Your affidavit.
No, can't help you. You have bad case. Madam, bad case.
If it is regularized according to the scheme.
What order I was proposing to pass, you should have allowed this court to pass. Here, how can I pass? Unless you bring that you are within the regular services of the state. We put that question, you file an affidavit. I give you time. You don't file anything. Dekho.
Just to bring to the record in the court also, in my
Not
affidavit of
necessary.
position also,
You say, I've seen that.
Lordship.
Clause 6 of the office memorandum dated 17/9/2015 specifically mentions that a compassionate appointment scheme for the state government employees who die in harness is applicable only to the dependents of the deceased government servants appointed and serving on regular basis at the time of death, and will not be applicable to those who are working on daily wage or casual or ad hoc or contract for re-employment extension consultant basis. A perusal of the writ petition reveals that the petitioner have enclosed herein the order of appointment of her mother, his or her. Petitioner is
His mother.
his mother, as Annexure 1. But the said appointment letter appears. But from the appointment letter, it appears that the appointment was on temporary basis. The council appearing on behalf on a temporary basis, and further, the said appointment was liable to be terminated in the event of discontinuation of the centrally sponsored ICTS scheme funding by the Government of India. Under such circumstances, the learned counsel appearing on behalf, the petitioner herein is directed to place before this court such documents which would show that the petitioner can claim appointment on compassionate basis in terms with the office memorandum dated 17/9/2015. Read with the addendum dated 9/4/2019. The said affidavit be filed on or before 13th of May 2026. List the matter again on 18th of May 2026.
Obliged, Lordship.
For admission, item number 5.
Your Lordship, this matter has already been adjourned in the morning hour.
Respondents have not filed affidavit in opposition. Madam, you have not filed.
Your Lordship, if 2 weeks time may be given to file affidavit, Your Lordship.
Chalo, if you don't file, we impose cost of 15.
Your Lordship, this is not my matter, so.
So what? Whoever it is, Mr. Imti Song is appearing. He's an additional advocate. So ask him to pay from his own pocket.
Lordship, he's in court too.
Huh? Call
He's in
him.
court.
We'll have after. It was because of you I put 10,000. And Imti Song comes, we'll make it 20. Next. Wait. Next.
For admission, item number 6.
Yes, what is this?
Lordship. An order has been passed by the village council, my lord, absolutely without jurisdiction. Denying or infringing upon my property rights.
What's the resolution passed by the village council? Where's the order?
Lordship. Page, there are two orders, my lord. One at page 99.
99.
And first one is at 99. There's a
Joint
resolution
village
following the
consultation committee between so and so and so and so. A joint village consultation in man. The Sui Mayor will henceforth maintain amiable and better with the family members of late K.T. Marg and others. Okay, that as long as she advised to be part of the party parliament, she can enjoy all the privilege of eating rightful wifey, pension, so and so, so and so. Be a dignified wife, she will automatically be deemed fit to forfeit all the claims and advantages.
Then Lordship may kindly see 115. 115.
You gotta stay.
Lordship.
You gotta
Yeah,
stay.
I've got this.
Huh?
Yes, I have this. Lordship, to the break or Lordship is taking a break.
Oh, yes. Let me come back. Just wait, let me take a. Mr. Imsong, why haven't you filed this affidavit?
Lordship, we have filed an affidavit in opposition. Petitioner wants to file the reply to our affidavit. Petitioner wants to file the reply to our affidavit.
There's no affidavit filed by you? When did you file your affidavit? There's no affidavit here.
Is it not available?
No. That is what, that is why the matter has come up. Affidavit in opposition not filed till date.
I think it is filed on the last occasion on 20th February. The petitioner counsel there's short time to reply to our affidavit. So I have to check my record also. Otherwise, it's a very interesting case.
When did you file? But
So-
why the learner had not yet filed the affidavit? That is the instructions given. It is also mentioned again.
If I'm not mistaken, sometime in the January before, this meter was part out once.
These are statutory rules. No.
No, this is a purely private school. Our condition is it doesn't attract Article 12. It's a purely private school.
Private school.
Yes. The name is second NAP school. The name is nomenclature of the school is such. Otherwise, it is
Private school.
purely private and no public function, nothing is there. So it doesn't attract Article 12 of the Constitution of India.
Who is paying for the school?
No, I am praying for the entire state, but none of the council
Oh,
is paying.
Madam, you have a problem. Where is Mr. Sentiangar? This reputation is not maintainable if the school is not a school, a government school. Not a government school.
No, private, purely private.
Yeah. And you have not made the school a party also. When will Mr. Sentiangar be available?
So he is on the way from Dimapur.
Oh, fantastic. 2 o'clock. We'll close this petition. You asked the registry, there's some affidavit file here. Mr. Imsong, kindly indicate when did you file the affidavit? We'll watch that one.
Lordship. Lordship,
Yes.
before I proceed with the facts, briefings, can I just point out can I just place the
Yes,
relevant-
yes.
relevant, statute, madam?
Hmm.
Well, the village council here, in this case, madam, is a purely a creation of the statute, Village Council Act. Duties, functions are given by. They cannot go beyond that. Lordship, the other day,
You are referring to section 14.
14, my lord, that's what I wanted to point out. 14 has been deleted way back in 1997.
No, again it has been brought in.
That is recently. 14 brought in that I'm not aware of.
Yes, 14 has been brought in. Because that is what, that day, Mr. Imsong, I was hearing another case.
My lord,
Yes.
here it's a deletion of section
That
14.
was deleted in 85.
Yes,
That was again brought in 2022 or something.
right? That's not official. No. All right, my lord. Even that, let's say, my lord, a custom.
But now the thing is, how section 14 was initially then there.
Yes.
in the year 1978 was that they are going to decide this. Now, when it was reinserted in 2000, whatever may be, an appellate forum has been now being given. You do one thing.
No,
Mr.
what she is like is, custom, my lord, if I may, just, custom cannot override the statute. Custom cannot be opposed to public policy. Custom cannot also be against morality, my lord. Here, my lord, just look at, and here, they want to derive my pension, my lord. And I'm not a native of that village. I don't stay there, my lord. Biggest thing, I don't stay there. My husband was a Rengma. I'm a Lotha. I stay in Dimapur. My property is in Chumukidima. The property they want to take away is in Chumukidima. This village council is Simanju district.
We have this matter along with the other matter. When it is the other one, when there is a case which I'm looking into it.
Now,
There's another matter, no? You just ask Mr. Im Song. He was appearing in that matter. That matter that they I was hearing.
That is fixed tomorrow.
Huh? Okay, well, let's have it tomorrow. Because there also the same question. The same question arises that this particular person has been for
sorry,
last.
but I have to bend this one because to support myself, my lord, I'm just bending this one. I'm sorry.
No.
I'm leaning here.
No problem. I'm saying that this particular case, which was there before me in the other, which I'm taking it up, was on the question of the jurisdiction of the village council. The reason is that this person has been residing in Dimapur for last than many decades. He has written something against some village.
Oh, yes,
That is Suntia village
Yes,
council
I'm
or
aware of
something
that.
he has written.
I'm aware of it. But that is the same village, no? He's from the same village.
No, he was.
No, he belongs, he's a native of the village, though residing in Dimapur,
Now he is residing
Yes.
in for many decades.
which is not my case here.
Yeah, no, understood. But here you stay separately.
I know, I don't belong to this village.
No, my question out there, which I have raised out there, that can a decision of a village council
No.
be given in respect to a matter which is beyond the village limits?
Yes,
Because the village have been defined in section 3
yes, ma'am.
to mean what is a village. A village has to be a recognized village. So when the word used in section 14 is they will pass a decision within the village limits,
Yes.
can they pass a decision which is beyond the village limits? Because this person made that publication in Dimapur. So that is the entire cause of action arose there. So can the village council exercise? Now here in your cases, it appears that you are not a resident there. You reside in some other place.
And don't belong to the villages.
Understood? You reside in some other place. And now you stay in Dimapur. The property is there in some other place
Other places.
and not within the limits of the village. So let's have it tomorrow.
Yes. And Lordship, the another thing is, can the village council have the authority, even otherwise, ma'am, to pass such an order?
Because you see, the pension
Yes.
is regulated by another
Sir,
law.
uh,
So that
rules.
law
Yes, ma'am.
has to be the village councils cannot override an order being passed under the pension code.
Yes, and Lordship, Article 21, livelihood, ma'am, property, Article 300A, all these are there, ma'am. Can I just come and say that on the basis of certain allegation, I have never used the title of Mark. My official name is Nuli. My husband is Sir, my late husband, also never used that. Just because I used that of my official name, I have disregarded. And do they have the power of contempt just because I didn't attend there? Well, they mistreated me. I didn't go there for the second time. Can such an order be exercised in the name of custom? My dignity.
Okay, then let's have it tomorrow
Yes.
along with the other. Let's the matter tomorrow. Mr. Jamil, you were there in the other matter with as respondent number 5. What is the number?
Together, man.
Tomorrow,
All right, making item number 5. Yes, my lord. My lord, I've filed my affidavit in reply this morning. If the affidavit is in,
you have been dismissed.
yes, lordship.
Now, why you are challenging the suspension order?
Suspension order, since that I've also met some grounds on the,
What is your ground?
my ground is simple, my lord. There was an irregular disciplinary proceedings. Rules of 1967 was not strictly followed. Second, no documents, no evidences which were relied upon by the DA was not supplied to me, and not even the inquiry report was also deemed necessary to supply it to me before imposing penalty under section Rule 10 of the rules of 1967.
So you had not provided those documents.
No documents, only the memorandum of charges was supplied to me. And after that, even written statement was not permitted to be submitted, lordship. That is why in my affidavit in reply, I have
Now, what do
enclosed-
they say in the affidavit in opposition?
in their affidavit in reply, they have stated that 10 days was given. Paragraph 8. My lord,
Petitioner was working as?
he was working as a constable, lordship. Branch constable.
And why is the chief judicial magistrate important here?
Lordship, a criminal proceeding is initiated against you.
But Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Ms. A.M.E. appears on behalf of the state respondent. The petitioner herein have assailed the order of dismissal from service, the penalty of dismissal from service, on the ground that the disciplinary proceedings which were conducted in terms with the provisions of the Nagaland Service Bracket Discipline and Appeal Rules 1967. On the ground that the disciplinary proceedings so conducted in terms of the disciplinary proceedings so conducted was contrary to the mandate of Rule 9 of the Nagaland Services Bracket Discipline and Appeal Rules 1967, on the ground that the petitioner was not permitted to submit the statement of defense and also was not afforded the various and was also not afforded the opportunities which the said rule mandates. On the other hand, from a perusal of the affidavit in opposition, it is mentioned that the petitioner initially, the petitioner, upon being served the show cause notice along with the statements of allegation, was granted 10 days time to file the affidavit to statement of defense, which the petitioner did not do so within the time mentioned. It is also mentioned that the petitioner also did not seek for any further time Further to that, the affidavit in opposition also shows that that the proceedings was conducted was conducted on 26/8/2023 and 1/9/2023, wherein the petitioner never availed any of his rights. And in the present writ proceedings, the petitioner has wrongfully, in order to mislead this court, have stated that the petitioner was not granted the opportunity. Mr. So-and-so, appearing on behalf of the petitioner, submits that the petitioner would like to file an affidavit in reply. Taking into account the above, lists this matter on 18th of May 2026. In the meantime, the affidavit on reply be filed on or before 11th of May 2026.
No, I wanted to submit it if the motion can be taken up on Thursday. For this
You have
person.
not filed it, no?
We filed it this morning.
You have filed it?
Yes, we have filed it this morning.
Then we'll take it up. It doesn't take much time. This is the matter. I would have given him an opportunity. I'll set it aside and give him an opportunity to again appear. That is what I feel. But anyways, you have filed it.
Yes, I filed it this morning, Lordship.
It has been submitted that the petitioner have already filed the affidavit in reply. Stop. Mr. So-and-so, appearing on behalf of the petitioner, submits that the petitioner have already filed the affidavit in reply and expresses urgency in the proceeding, taking into account that the petitioner have been dismissed from service in the year 2023 without following the mandate of the Nagaland Service (Discipline and Appeal Rules 1967. Taking into account the above, lists this matter on Thursday, on which date an attempt shall be made to dispose of the petition. Working Nalani.
For admission, item number 8.
Yes, Mr. Bimami,
Yes, my lord.
what is the matter about?
My lord, this is about the 4 non-Naga tribes of Nagaland. So the scheduled tribes order of 1917 is already there. The 4 tribes are scheduled tribes of Nagaland along with the Naga tribes. Now, to tackle the issue of illegal immigration in the state of Nagaland, a decision was taken by the state government to have a register of indigenous inhabitants of Nagaland for short RIN. So modalities were worked out and a notification of 28th September 2024 was brought out. We are very happy with that. That applies across the board to the Naga tribes as well as the 4 non-Naga tribes. On the same day that notification.
Mr. Jimami, if I remember, because there was one matter before
Yes,
me.
yes, madam.
Let me tell you the facts, which as it appears, as I remember, in the year the state of Nagaland attained statehood on 1/12/1962.
63, madam.
63. In the year 1977, the notification was issued.
Yes, madam.
Whereby they said, because in the year 1970, the scheduled tribes order, which is given under 342, Article 342 was given, whereby Nagas were brought and the 4 other tribes.
Yes, madam.
This Naga tribe has 15 sub-tribes.
Yes, madam.
If we say it to be, although they are not sub-tribes, they are all our tribes, but for the purpose of the constitutional order, it will be construed that these 15 sub-tribes will be there. Now, in 2016, another notification came by which they, in the 1977, they had the 3 modalities to find out.
Madam.
One is as to whether their names were there in the electoral rolls. Number 2, as to whether they were paying house tax.
Madam.
And number 3, whether they had issued any patta and all.
Yes, ma'am.
These are the 3. In 2016, there is another notification which says that it is in supersession of the earlier notification of 1977. But the certificate which is mentioned therein
Madam.
categorically mentioned that these are the three parameters which are there in the 77
Yes, ma'am.
notification. This is there. Then the state of Nagaland had formed some commission.
Ma'am.
Now, this commission had made certain recommendations which
Yes, ma'am.
were to be done. In pursuance to that, you have two notifications issued on 2010-2024.
29, ma'am.
29, 2020. One is a notification specifically in respect to those 15 Naga tribes.
No, my lord. That's where the problem arises. It applies to all the tribes, including the 4 tribes.
No, for the 4 tribes.
Yes, my lord.
There is another
No, my
notification.
lord. That is where the error has crept in. That is my case, ma'am. Now, if your lordship will see the notification of 29, the notification of 29-24 specifically says for the Naga tribes plus the 4 tribes. That is where the error has arisen, madam.
Let us see that.
Now, the notification of 29-24 is at page 102.
No, 10.
Yes. Page 85, my lord. Page 85. 29-2024. At page 85. May I read, my lord?
No, Mr. Counsel. There is another notification of 29, 2000.
Yes, my lord, there are 2. But this is the first one.
No, exactly on the same date, there are 2 notifications.
Exactly, my lord.
Where is the other one?
But this is the first one. This is the first one. This is the first one. That is what I'm trying to say, my lord.
Now, why you are saying 2 notifications? This is the first one?
They are on the same point, my lord. And may I just take your lordship to the notification first?
Yes, 102.
Yes, no, 85, page 85. Page 85.
Yes. This
85.
is the other one.
Yes, this is the first one, my lord. So, in order to protect and safeguard the interests of the indigenous inhabitants of the state of Nagaland, and for the purpose of streamlining the qualification for eligibility of being an indigenous inhabitant of the state of Nagaland, and taking into account the recommendations as made by the Commission on Register of Indigenous Inhabitants of Nagaland, and considering all other relevant aspects of the matters, and in supersession of all the previous notifications, guidelines, and orders issued from time to time by the government on this subject, the following criteria are laid down for issuance of IIC. IIC of Nagaland can only be issued to citizens belonging to any of the 15 recognized Naga tribes, namely such and such, as notified by the who are up to Ziliang, my lord, with Kachari, Kuki, Garo, and Mikiri, as notified by the Constitution Scheduled Tribes Order of 1970, who are resident in the state and are considered as indigenous inhabitant of Nagaland, provided that the person can trace their antecedents to a recognized village in Nagaland. And so the whole list of criteria and how this is to be brought about. Now, after this, the type copy is done, then we come to page 102. That is the next one. Now, this is an order. This is an order. First one was a notification. First one was a notification. And the second one is now an order. Dated 29/2024.
Where?
At page 102. On the same day.
Yes.
On the same day. May I read, my lord?
Whereas, in pursuance of the cabinet decision dated 12/9/2024, with regard to the eligibility criteria of being an indigenous inhabitant of the state of Nagaland, an issuance of indigenous inhabitant certificate and enumeration exercise is to be conducted of the people and their direct descendants from Garo, Kuki, Kachari, and Mikir. This is my problem. So now we are segregated.
Yes.
We are segregated.
Yes.
This is my problem.
Why?
And now I'll come to that. Kachari and Mikir.
No, because there is a cabinet decision prior
Yes,
to
my lord.
that. There is a cabinet decision which categorically says
My lord.
that in respect to the
Yes.
Nagas, you are not, it is irrespective of location. Where is that cabinet decision? This is not the entire
No,
location.
no, my
decision. Because what has happened, as I remember, the cabinet decision which is there, they had put two things. One is as regards this Garo and all these people,
My lord.
because they may not be all residents of the or may not have founding fathers out there or the forefathers within the jurisdiction of the state of Nagaland.
My lord.
But in respect to others, the Naga, they
My lord.
may have it.
My lord.
They are most likely to have it. So they, therefore, in the cabinet memorandum which was there, and there were these cabinet memorandum, they have therefore segregated in respect to those persons who are Nagas and those persons who are the other four tribes. Therefore, you find the 110 notification, which is there. This is it. So there, here they have put it in pursuance to the order dated so and so and the year of 28th of a month so and so from the Home Department and so is to be conducted so and so. Settled as in the state of Nagaland prior to so and so, Nepali Gorkhas, because there is another resolution passed in the year 1940 as regards the Nepalis and Gurkhas.
My lord.
So they are regulated, although they are not tribes, but they are recognized tribes in the state of Nagaland,
Yes,
but they have been given this benefit, but if they have to be resident prior to 1940.
My lord. My lord. But the Nepalis and Gorkhas stand on a different footing altogether, my lord, as the Lordship has already said. Now, my lord, what is the cabinet decision of 11th September 2024?
Yes.
Your Lordship will see that in page 100.
Page?
100.
Yes.
And at agenda number 2, Register of Indigenous Inhabitants of Nagaland. Can you note the heading also, my lord? Register of Indigenous Inhabitants of Nagaland. The cabinet discussed and approved the draft notification containing the eligibility criteria of being an indigenous inhabitant of the state of Nagaland and issuance of indigenous inhabitant certificate. What is this, my lord? This is the notification of 29. This is the notification of 29, not the order of 29.
Okay.
This is the notification of 29. And this is for Register of Indigenous Inhabitants of Nagaland, which includes the 4 tribes, my lord.
Yes.
Which includes the 4 tribes. Further, the cabinet directed the Home Department to immediately start enumeration of only the 4 tribes. And on what basis? On what basis now, my lord? On the basis of not the criteria which is notified in the notification of 29/2024, but on the basis of the order of 21/2024, which is at page 100. And what does the order of 21/24 have? Kindly see that, my lord. Kindly see that.
Yes.
102, 103, come to page 104. Come to page 104.
Yeah.
And look at the format, my lord. Look at the format at page 104. The only criteria in the column, in the broad column, in the third column on top, my lord, electoral roll of 5/12/1963. That is all.
Now that I know.
That is all.
No, this aspect I know because that day this matter came up before me. I remember that. Now let's see the affidavit which they have filed. They have filed.
The government has admitted everything, my lord.
I'll see.
Yes, my lord. It is a very interesting affidavit. The government says
they have filed this affidavit.
Yes, my lord.
Finally come to paragraph number 5 and 7.
We can start immediately from paragraph 3, my lord. Paragraph 2, paragraph 3.
No, paragraph 8.
Yes, my lord. That is regards to the contents of
the impugned instruments are in continuation of the earlier policy to ensure accurate identification prior to event. Paragraph 8.
Yes, my lord.
So it is, Mr. Jimo, it is only on this aspect.
Yes, my lord.
Why the matter has been put today as to whether to get this particular clarification as to whether the 3 aspects, because what was the only worry is that you are now restricting only in respect to the electoral rules.
Yes,
but you are not giving the benefit of the other
two
where, because in many cases, many persons may not have this electoral.
Could not have been done.
So at that point of time, may not have been.
Yes.
So you could not have restricted only them.
Yes,
and in fact, and when it has been the policy all along to have the 3 parameters. In fact, in the year 2016 also, this parameter was followed. So therefore, now to say you are removing these 2 parameters takes you of your right. But this paragraph number 8 says it is in continuation of that.
Yes, my lord.
That is why I'm saying.
That is one point, my
Let's
lord.
hear the Advocate General on this.
And not only that, my lord, in the affidavit, they repeat in every paragraph that 29-24 will be uniformly applied.
No, there cannot be. The thing is, as I could understand, this particular document, which is there, the affidavit, the amended writ petition is being filed here.
Yes, my lord. The amended writ petition, why I filed, my lord, may I explain? The amended writ petition. After I filed the writ petition, a stay was granted by the Honorable Court, and the enumeration process was kept on hold. Now, because I came before the Honorable Court and got a stay, an order was a cabinet, a decision was made that the 4 tribes do not be issued with IICs. I had to come before the Honorable Court again by filing an IA, get the petition amended, and ask for a stay again.
Protect and safeguard the interest of the indigenous and for the purpose of streamlining so and so. Yes, Mr. Advocate General, what do you have to say?
My lord, the issues which my learned friend has pointed out, that can be sorted out in a simplistic way. But more serious issues are there in this case, which I've been informed personally. In fact, the Kachari tribe, which is there before this honorable court, who were ruling Dimapur also at some point of time, they have approached the honorable chief minister, stating that they want to withdraw the petition. And the circumstances in which they have approached the court. And this exercise is continuing. And I'm told that today also there is a meeting with the honorable chief minister and these people. This is number one. And maybe the other tribes might follow, except maybe the Kukis, who are having serious problems with the Naga settlements in Nagaland and also in the border town. That we'll look into later. But what's the utmost significance here is, my lord, I think specific affidavit has to be filed, because after going through the affidavit, what might have occurred to your lordship is what exactly is the purpose? How do you differentiate? That doesn't seem to have come on record appropriately. Therefore, taking into consideration that this talk is going on, and I've personally seen the letter also which was sent, and may not be proper to explain the whole thing before the honorable court. And when the government itself is seized of the matter, I think we will look into that as one aspect and also file a proper affidavit. And since the matter has already been heard and my learned friend has made his submissions, Lordship may kindly keep it as part heard and keep it.
No, I don't stay here.
Then my lord, then give us some time. We want to file this affidavit. This affidavit is of utmost importance in this case.
But
why I say that, my lord? I tell you,
no, Mr. Advocate General, here the only issue is this.
I get the point, my lord.
The only grievance of the petitioners herein is, although you say, but one thing is that day I was taking up that particular PIL, that it appears that the decision of the government, insofar as the Naga tribe is concerned, it is not location specific. They can very well show that some ancestor out here was there.
That's it.
Whereas in the case of the other 4, the thing is, it is not locations, it is location specific. They have to be residents out here somewhere to get that indigenous certificate.
In fact, Your Lordship, in the affidavit of the state, they have filed another document, which is Annexure B, and they prescribe some more modalities on the basis of which RIN will be issued. Can you see that?
Of which?
Annexure B, my lord, 10th April 2025. I was coming to that.
In fact, this covers more or less everything, my lord. At page 22 of the state affidavit.
Yes, if this is the this is to that in continuation of the notification.
Yes, my lord. Continuation of the notification. The 29 notification.
Okay. Serial number of the applicant, A5 digit 6 of the year for the district where This is in respect to the notification.
Yes, my lord.
But not to the order.
Not to the order. That's why I was making a specific point on that, my lord. The notification is prescribed modalities.
Modified
In
form.
fact, this more or less covers the 1977 order, my lord.
So this is the updation.
Yes, my lord.
Annexure 2,
Annexure B.
page 25.
Yes, my lord. Yes.
Now, Mr. Advocate General, is it the case of the state now that in respect to the other 4 tribes, you are not going to take into consideration the other 2 aspects as to whether they had a house prior to 1/12/1963
Right. Right.
or they paid house tax and as per 1/12 prior to 1/12/1963? Is it the case of the state?
Please, madam.
Is
No,
it?
another point for consideration, Your Lordship, was what about the Nagas who were staying outside?
Huh.
That is what I want to put on affidavit because I've heard them orally.
No. For that, you have the other PIL. You see, what is this enumeration? The enumeration is more of a delimitation process. You see, this court normally would not like to, this is absolutely between the state as well as the citizens.
Correct.
This court would not like to interfere. But my only question is, are you applying the 3 yardsticks which were there in the year 1977 for these four Nagas, for the other tribes? Because this has been the one which have been followed from 1977 onwards.
That's right.
If you are following that, then what is there to keep it?
No,
You are the Advocate General, you can very well say that. Because
would have
it
seen the
emanates from this Annexure B.
Right.
Yes, as regards the other Nagas, it is the subject matter of the other PIL. Whether what will happen if a person is outside, who has been, or just take for an example, a person, another being born out there in Eastern Nagaland,
Yes.
forefathers, prior to 1963. And thereupon they migrated out there to Delhi.
Well,
They're residing
my
out
lord,
there.
we have Nagas in Assam, we have Nagas in Meghalaya, we have Nagas in
But they may have some roots.
they may have some roots. Yes.
See, Nagaland has some roots somewhere.
Yes.
Normally, Nagas will have some roots everywhere in the state of Nagaland,
Yes.
because you have this, all these districts are there where it is specific to a tribe.
My lord.
So they may have this, because the Nagas are of the 15 tribes,
Yes, ma'am.
which are either a part of the district or in some districts or other, they may
Yes,
have
ma'am.
some relation somewhere. That is one thing. So here, as it appears that in respect to those persons, if they show their forefathers, kindly see this particular document of the affidavit at Annexure 1, page 19. And more particularly C and D. C at page 20, family details, what is required as
Yes, madam.
notification. Name of the biological father along with surname or family name, issue and IIC certificate. So if there is an IIC certificate given at that point of time,
Madam.
that would be enough. Biological father's date of birth, name of so-and-so, ancestry, name of the tribe, name of the biological father, paternal grandfather, village name, biological father of entry, biological grandfather, name, mother's name is also there. Biological mother's name is there in C. So here, if we look into it, it is the state's very decision out there that if you have some ancestry somewhere,
Yes,
in
sir.
respect to these Nagas, no problem with that. But in respect to this, the only problem which we were having as regards the other 4 tribes
Yes.
is that in the format of enumeration, they have not mentioned.
Yes, ma'am.
So if that, the only answer is if that notification dated 29/2024 applies to you, then there is a requirement of changing the format, nothing else. Mr. Advocate General, that is the only thing.
I have a suggestion to make. In
And
fact,
situation-
I am trying to find out who were the authors of these notifications, the officers concerned. And many of them appear to have gone on deputation also. With utmost respect, I want to point out that this is actually a very serious issue which can have serious repercussions. It's not as simple as it looks like.
No, understood, Mr. Advocate General.
Therefore,
It's a serious issue. Why you are putting the ball in the court, ball in the court of the court?
No, in fact, I concede. I've gone through the affidavit which has been prepared. I would not like to make any comment on it. It may not be proper on my side. That is why I want to reinforce the affidavit in accordance with law, which would give exact existence which the court requires. My lord, this being a very sensitive issue, it should not happen that something has been missed out here or there. It is precisely for this reason I want to undertake that. Otherwise, I would have never asked for filing an affidavit if I was satisfied.
No, it's okay. You want to file an affidavit, you can file an affidavit. But we narrow down the issue to the effect that the issue pertains to as to whether if the notification dated 29/2024 applies to the 5 recognized tribes as per the constitution. Is there a requirement for amendment of the format? It's a format.
Format, madam.
The format, the enumeration format.
Oh, the modalities, madam.
The enumeration format.
In the 2024
format.
In the 29 notification, there is no format. Like
No.
Format, madam, yes.
No,
Format.
29 notification
Yes.
is the format. That is
Format, madam.
has
Yes.
happened. Notification
Yes, madam. Yes,
categorically says
My apologies, madam. Yes.
Annexure 1. Annexure 1 is
Yes. There's a format.
So that form is there. Now, after this form comes the another one, which is there on 10th of April 2025. So the only thing is as to whether the notification of 29/2024 would apply to all of the 5 tribes.
4 tribes.
I would put it this
4
way.
tribes, including the Naga tribes. Yes.
I would put it this way.
Accepted.
Without making any observations on this in a particular way. I would seek the liberty of this court to address these particular issues in the form of an affidavit. Instead of now stating that to do it piecemeal, give me that kind liberty. So that I can
you file your affidavit.
will file.
That's why you need to file the affidavit.
Not make any observation, my lord. That's
No, I'm not making. I'm not. I'm saying.
I've understood.
No, Mr. Gopal, kindly appreciate. This court is not making an observation. I am only crystallizing the issue.
Yes.
I've got the point. I'll meet
You
that.
file an affidavit on that aspect. Because
do that.
what is there, it's affidavits which have, you see, Mr. Advocate General, you must be aware of various judgments. When the state normally files an affidavit, it is taken to be that affidavit is taken to be the stand of the state. But if you want to change the stand or bring something more to that, then leave has to be taken. The leave has to be taken on the grounds.
Yes.
There has to be specific grounds for that. But therefore, my question is out here. Let me crystallize the issue. Why you need to file the affidavit? I'm not saying anything as to whether you are entitled. What you say, it's yours. I'm not commenting on. But this is the crystallized issue as to whether, by virtue of the order of 29/2024, the notification of 29/2024 is not applicable to the 4 other tribes. That's it.
I would put it differently, in just with respect.
You just come up with your answer.
As far
But
as
you have issued a notification on 1/10/2024.
I am saying, as far as
You see, Mr. Advocate General, there's a stay. Which stay I don't like these matters.
No, my lord. If I may, the time frame for this enumeration exercise, Lordship, was from 1st of. Show me that 1/10/2024. Your Lordship can kindly see the 110/2024 notification, which is at page 108.
In the state.
At page 108, the time frame.
Of the writ petition.
Yes, of the writ petition.
Yes.
Yes, in the middle of the page, schedule for the enumeration exercise. Has Your Lordship got
This
that?
is on 8th of May.
1st October 2024. And it was to complete by 6th May 2025. I filed my writ petition on 5th May 2025. Nothing was initiated at that point of time. I got to stay on 8th. Nothing was initiated, my lord. Till today, no exercise has been initiated. There is something more than meets the eye, my lord. There is something more than meets the eye. Nothing has been initiated.
I will explain all these points. What were the circumstances which was prevailing in Nagaland at that time?
Nothing was initiated, my lord.
From so many institutions, so many people, and they met each and every person who was connected with
It is not as if a stay was granted midway, my lord. Nothing was initiated.
And these very people who have filed the petition, one of the main persons.
And not only that, my lord, the chief minister of the state has gone on record, public statements saying that the 4 tribes, you should be happy that they are part of Nagaland. We give them what we want to give them.
He cannot challenge the nitty-gritties of an implementation of
I
law.
agree with
He
that
has
also.
specific reasons why we are doing it, my lord. It's very sensitive. It was not that the state was avoiding it. It was trying to implement it. We had the best officer.
And the perception
retired.
put in a public media, my lord, that the enumeration
Things are
exercise
there.
has not gone forward because of the declaration of court. No, it was never initiated in the first place.
And if that is so, why would their chief come to the government today and say, I want to withdraw my petition? He has given a letter on this March to give all the details that I was misdirected. So therefore, my lord, I will address
Pressure is being put on the petitioners, my lord. Pressure is being put on the petitioners. The lawyer is making statements about some petitioners. I know for a fact that tremendous pressure has been put on the petitioners.
I am only saying this, my lord. A comprehensive affidavit will be filed. Not that I am going to go against my own affidavit. I will not go there.
Can't go against his own affidavit, my lord. Everything is admitted.
Let me make my submission.
Discrimination is admitted, my lord.
Therefore, I will clarify all these points in the form of an affidavit. It is a very, very sensitive matter, my lord. The government, what are the people pulling the government from this side to that side? We all know it. It's all in the press also. So I will file a comprehensive affidavit which will satisfy the matter. Then the matter can be looked into.
As the notion was already
all earnest effort.
My lord, it cannot be a comprehensive affidavit anymore.
When I'm seeking for a time, why is you objecting to it? Therefore, my lord, we'll prepare a proper comprehensive affidavit which will meet the ends of justice, so that this court can apply its mind, which will meet all these points which your lordship has asked. And I have kept in mind the very questions which this honorable court has raised. We'll do it, my lord. Give me at least 4 weeks' time, I will do it.
Then if you're asking for that, then you give a stand as that you are not going to go ahead with the enumeration proceedings.
Well, as far as that is concerned,
don't put the blame on the court, Mr. Advocate General. Then you say, give a stand, a statement to that effect that you are not, as you are asking for time.
As far as
I don't want to put the thing with the court out there that there is a stay operating out there, and that the state is not. Now, if you want to file an affidavit, file after 4 weeks, whenever you feel like.
Whenever
but you say that you are not going to go ahead with the enumeration
before this court, my lord.
Huh?
Your lordship should have faith in me. When your lordship says this is the point, we'll take care. There won't be any order. And there we will do it. That's not non-issue.
No, Mr. Advocate General, I'll grant you time. But how much time you want the petitioner would not be agreed by you taking time, provided you don't go ahead with the enumeration. You give a standing that because of that, not.
I am only saying this, that as far as this case is concerned, it is not that when we are ourselves asking for time, and in fact this matter has been stayed for such a long time, that we are going to jump into anything. Whoever asks for stay, rest assured, we will not move. It's my statement. We are not keen on going ahead because we want to find out exactly what is the question. Maybe we are wrong, or maybe we are right, or it requires.
Okay. No, Mr. Advocate General, say, okay, there's no problem with that.
That's what.
We recorded that you have given a statement that you are not going to go ahead
Until the next day, matter is heard. I have no problem.
Yes.
And
So,
Dr.
I
mentioned
think
that they're going to
the
the
question
matter.
of continuing with the interim order does not read rights. Because you see,
Either way, I have no problem.
The Advocate General is saying, I would not.
My lord.
But when the Advocate General is saying, we have
Very
to
well.
take note of that.
Very well.
Yes, because he is the first officer of the
Yes, ma'am.
state. Mr. So the learned counsel who appears on behalf of the petitioner. And Mr. A.G. Balagopal, the learned Advocate General of the state of Nagaland, who appears on behalf of the respondent and is assisted by so-and-so, who appears on.
Even the names, my lord. Senator Sema and Mr. Bilal.
Mr.
AG has got the name.
Advocate General submitted that in view of that an additional there is a requirement of filing an additional affidavit on behalf of the state to bring further material particulars which would be required for a proper adjudication of the dispute involved in the instant proceedings. He therefore submits that 4 weeks' time may be granted to the state to
Maybe 6 weeks, my lord, she was telling me.
6 weeks' time may be granted to the state for filing such the additional affidavit. This court had also taken note of. Mr. A. Jimomi, the learned counsel appearing on behalf of the petitioner, submits that there is an interim order and the interim order is required to be continued. This court inquired with the learned Advocate General as to whether the respondent state is proposing to take any action, further action, taking into account that the notification dated taking into account that in terms with the notification dated 1/10/2024, the period for conducting the enumeration is already over.
Already over.
The learned counsel, Advocate General submitted that taking into account that the present matter is pending, the state would not be taking any further action, as it is the statement of the learned Advocate General, this court does not find it necessary that any further interim order is required. Lists on, can you file it by, can we have it on 18th of May? 18th, it will be 6 weeks. Can we have it on 18th or 22nd of May or 25th of May?
It is fine.
25th of May would be.
25th of, list the matter on 25th of May. Affidavit be filed on or before additional affidavit of the state be filed on or before 25/2026. I have put the burden outside the court.
These are very tricky matters, my lord. Somewhere we miss by we don't look into a document.
We also have to be a bit tricky, not to put the blame on the high court.
No.
Okay.
For admission, item number 9.
What is this?
Lordship. My lord, I wrote
Matter pertains to land matter.
yes.
Wow.
Your Lordship, in this case, the state respondent, Mr. Moaim Chen, he is on leave. But I am for the private respondent.
The land has been settled in your favor.
It has not been settled, Your Lordship.
Lordship, it has been declared a public road. The land, my lord, the land has been declared. The land I had received in exchange. I sacrificed a piece of land and then I got this land. And this is the land on which I built my approach road. Constructed my approach road, the road to my residence. A complaint was made by the private respondent saying that this is not a private land, this is a public road. And the revenue authorities in a revenue proceeding has decided that it is a public road and not the land of mine. Therefore, my lord, my case is that in a revenue proceeding, they have decided ownership of the property of the land, which can only be done by a competent civil court. Right to title interests.
Let's see the order.
Lordship, may kindly see the impugned order at page 26. May I read this, Mama?
So against this order,
Yes, my lord.
where there's no appeal.
There's no board, my lord. There's no revenue board in Nagaland. So therefore, we come under 226.
I have raised a preliminary objection on my general plea on that. And there is already an order passed by appellate complete appeal, Your Lordship, that against an order passed by a revenue deputy commissioner on the revenue side, sitting as revenue court, Your Lordship. If there's a statutory appeal, that is okay. Otherwise, the civil suit, Your Lordship. There's already an order passed by the Honorable Court by an in-writ appeal 1 of 2024, Your Lordship.
No, against this order, basically a writ will lie.
Yes, ma'am, that
If statutory appeal, if there is, in Assam, Your Lordship, there is an Assam Revenue
But
Board.
then also,
But
but the question is there's a one big problem with this. You see, there are two aspects of this order. One is the finding of fact that he is in excess of 14 lectures of land, which I can't touch it.
Yes.
Under 226.
And which is not disputed, ma'am.
But they duly recognize his land is 3 kathas. 3 bighas.
and then that road, the road over which he has constructed the gate does not fall within his.
So that is another thing.
Yes.
But can the revenue court or the deputy commissioner direct removal? Under what power? There the jurisdiction lies. Under 226.
So what
Because that exercise, if it is not said to be a common land, you cannot exercise Rule 18.
For that, perhaps Your Lordship is right, Your Lordship, a different procedure for that, but it's a public land.
If it is a public land, you go under the Nagaland public land.
Yes, yes.
But you can't pass this order.
It's in part.
That portion. First part is okay. I cannot touch it.
Yes.
As to whether he is in occupation of 3 bighas or 3 bighas, 14 lectures, I am not there. I can't look into it. But if he has to be thrown out, it has to be thrown out if it is a government land in terms with the Nagaland eviction. 71. Not by this. Indeed.
That is the approach or used by all the public, Your Lordship, for years. For years.
That.
Yeah.
But that is the power you have to exercise. And that power is not given to the DC. That power will be given to a particular person. The authority is different. The state officer.
Authority may be the same, but not the revenue court, not the RO.
Not the deputy commissioner. In these proceedings. Yeah, he has decided as a revenue court. It's okay, it can be very well, because the power to demarcate is absolutely within the power of the revenue. They demarcate it and find out, yes, he's in excess of 14 litres, but he can't direct them to dismantle.
To dismantle.
That's it. Long and short.
If this is it's a public land, my lord, then the eviction act only, my lord, there is no.
So
that is the only thing.
The first
Keeping
five,
the matter, Mr. Jami, pending makes no sense. But this is the way how it is.
Then there are two parts.
There are two parts.
The first part, the finding that.
As regards whether he is in occupation, it is for him to file a civil suit.
Yes.
That the person,
Lordship.
he is not, he has to file a civil suit. But as regards the eviction, it has to be done there.
Lordship.
Now, the moment there is a bona fide dispute involved, then you have to file a suit.
Lordship.
It's a dispute.
Anyways, what to do?
Then Your Lordship may dispose it on that line.
But Mr. Moa Inchan is not there. I can't dispose
No.
of, but this is what it is. Because in principal seat, this is my bread and butter evidence. Because I take up bench 4 and bench 5. These are all matters which I keep on taking. So
28, yeah, no.
I have, I remember it by heart, the entire provision, how it is.
The next Monday, yeah? 30. Then Your Lordship, he has taken leave till 27th, on 30th, on 20th, week's day.
It has been submitted that the counsel for the state respondents, Mr. Muan Chin, is not present today, and he is on leave on account of certain personal reasons. Considering the above, list this matter again on when? I'm not there, I'm only there this week. When do you want it?
30, he has taken leave till 27th, 30.
30. So on 30/3/2026, interim order passed earlier shall continue till then. But this is what it is. May it's this. Where is Mr. Senkinger? You got the affidavit?
Lordship, it is not, I think, most probably we have submitted, hand over our affidavit to the junior of the Sindianger, which is, clearly stated by one of my junior. And in the meantime, that affidavit might have rejected in the filing. And this morning I checked, it is not available. Otherwise, on 3 occasions, the petitioner counsel has made a submission to the court that he requires some more time to reply to our affidavit. But
Understood, but
Yes.
still remains that the affidavit is not filed.
but in the record, it is not filed. So I have
Have they
rejected.
violated the affidavit
Yeah,
is not
definitely.
effective.
I presume that our affidavit is rejected.
So rejected, then obviously it is not filed.
Yes,
The petitioner seeking time is different, but otherwise it is not filed.
but copy was already given to the petitioner. So at least, Your Lordship, if you grant some more time to sort out all these issues.
But tell me why. One thing you are saying about them. This is here the documents reveal that some persons have been appointed are retired by the commandant with second NAP battalion. Why?
Your Lordship, yeah, the thing is, this is purely private school run by the second NAB personnel. But it is purely school, each of us are purely private.
But why
Your Lordship,
school these people are retired by the second commandant?
see, normally that school, since it is initiated and established by the police personnel, second NAB, whoever comes as he is a chairman of the managing board, commandant is a managing board. So whatever passed by the managing committee of the school, he comes, they put their rank and file on the shield. So by going to the documents, we presume that is a government school, but this is a purely private school run by the personnel of the second NAB from the very inception. And in my affidavit, of course, I'll file recognition of the school by the school education. Everything is there, and it is run by the resolution of the managing board. And all those managing board are police personnel, second NAB.
What happened to your senior?
He's on the way.
Oh. It is seen that though the petitioner have sought for various opportunities to file the affidavit in reply, but the affidavit in opposition which was filed by the petitioner, by the respondent, is yet to be brought on record. On inquiry, it had come to light that the said affidavit in opposition have not been brought on record on account of certain technical objections by the registry. First, the council appearing on behalf of the state is directed to clear up those objections so that the said affidavit can be brought on record. List this matter again on 24/2026.
For admission, item number 10.
Yes, my lord. My lord, I mean, allowed to take to the notification 2018. At page 15, next one.
Yes.
Here in the first paragraph,
states that Lordship and I mean, without to it, Lord. 1A. It has been laid out by notification so and so dated 26/7/25 that no land shall be acquired free of cost and all land shall be recorded on payment of full compensation as given by the law. No further condition for employment in service of contractual work should be entertained. Therefore, in case any department has entered into any agreement with the landowners in deviation of the land laid down policy on or after 2005, such agreement shall be treated as null and void. The department concerned shall take necessary actions according to nullify such agreement. In case the department concerned is of the view that the agreement should not be declared null and void, it shall refer to with relevant details given jurisdiction to the Department of Land Revenue for examination and advice on in consultation with PNR and Justice and Law Department, and thereafter submits the matter for consideration and decision of the cabinet. Lordship, the land in question here, where the office has been set up, the land was donated in the year 2018, after 2005. So, in view of the notification, in respect of 1A and B.
No, Mr. Council Kalisi, you approached after the respondent number 5 had already been appointed.
Not sure.
While on your basis of land appointment, landowner, we should disturb the appointment of the respondent number 6 or 5. And that too after you have approached this court after 6 years. Appointment made in 2006. Then you are going ahead, you are claiming in 2023. Why should we disturb his appointment?
Lordship, his appointment has been made without considering without advertisement. Without advertisement.
No advertisement.
Not advertisement made. And that is one ground that I'm taking, Lordship.
I have still not received any instructions, Your Lordship, in the department.
Without following the due procedure of employment, that is
Why should
1416.
Why should we interfere at your behest? Taking into account, this is a case you approach after 6 years.
Actually, that has not been explained in the petition, but
Would it be proper on your part? You have a claim very well, they will look into it later on, whenever there is a vacancy like this. That's all. We are not going to interfere with this. After 6 years, we have approached. This is a ground of delay and latches we should dismiss.
Lordship, in that case, Lordship, if I were given an opportunity to amend my petition, filing my appropriate on delay.
What amend and do one, what?
Explain delay in approaching the court.
No, what is the delay? You cannot explain because you approached after the appointment. Appointment made in the month of May 2019. You approached them for the first time in June 2019. See? Kindly see your first document.
Lordship, if I may, Lordship may come to page.
Kindly see, 25/6/2019, Annexure 5. This is the first document which is being given to the principal director.
No, Lordship may come to page 17, Annexure 3. Prior to the appointment of the respondent number 4, my application has been forwarded by the principal director.
Forwarding whose names?
Lordship.
Whose names are being forwarded?
Yes. But forwarding the application in respect of the petitioner.
How do you know?
The post of medical attendant.
Of so and so for the post of medical attendant.
That is department document, June 2018. 27 June 2018. So that was prior to the appointment of the respondent.
Then he was appointed in 2019. Why have you approached this court in 2000 year? Very difficult.
If I may given an opportunity to explain on the delay.
There is delay. Request for termination and replacement for the post of so and so and so and so. We have not even raised the issue. As the service upon the respond number, who is paying for the private respond? Have you joined that post?
Yes, sir.
And why this is an allegation? But how did you get appointed?
We received instructions from that.
Huh?
I am indigenous inhabitant of the street. So as per the notification, indigenous inhabitant can be appointed in a grade 4 post. However, with regard to the allegations made by the petitioner that the post has been advertised or not, I'm yet to receive instructions. Sir.
The writ petition was filed in the year 2025.
Yes, sir.
12/6/2024. 24 or 25?
24.
There it was kept under defective. 12/6/24, 25. And then notice was issued and till now you have not received anything.
Yes, Worship, with regard to that.
Chalo. We do one thing, you have not filed your affidavit, don't pay him the salary. No salary.
Worship.
No salary.
Let me be allowed sometime.
No. No salary to you. Here's a case made out. No salary. Then you will realize why haven't you filed? I'm surprised you don't have your instructions. How you have been appointed?
We're seeking some documents, it seems, Your Worship.
How can you seek for the documents for 1 year? And why the government has not provided instruction?
I've sent reminders, Your Lordship, but till date, I've not received any comments or instructions, Your Lordship.
Okay. You have to get the instruction from whom?
From the director through the
Principal director.
Yes, Your Lordship.
Okay. If the case of the petitioner is awarded, the entire salary which has been paid to him shall be deducted from your salary.
Yes. Also, Your Lordship.
If the petitioner's repetition is allowed,
Yes,
there's an illegal appointment.
Lordship.
So the entire amount shall be deducted from your salary and put to the public exchequer. Because a person should not have been appointed by this way. We cannot recover from him the money. So we have that the amount should be deducted from your salary, as you have not produced the instructions.
Some time will be given, Your Lordship, as the last opportunity.
Okay, tomorrow. Get your instructions. List the matter.
Friday, Your
tomorrow.
Lordship.
Else we are going to list the matter tomorrow. So a final opportunity is given to both the state respondents as well as the private respondent to produce the necessary instructions on what basis the private respondent was it. Failure to do so, this court shall be constrained to pass interim directions.
For admission, item number 11.
Yes.
May it please my lordship. Lordship, I filed a short affidavit in reply.
What is your case? That day I wanted to dismiss it.
Yes, lordship was
What is
in
the case?
that was lordship inclination. However, I have filed a short affidavit in reply that as to why my lordship will magnanimously
not exhaust the right of the landowner. Lordship, here is a,
Oh, your case is a case whereby you claim ownership on the basis of the claim appointment on land ownership.
Lordship.
Whereas the petitioner, respondent number 5, have been appointed on the base, is being regularized to the post.
Yes,
after
Lordship.
31 years.
Yes, Lordship.
And
That
this
is
is done in terms with what? Done under the, in terms with the
in terms with
2004 notification.
OM 9 to 2004. Under OM 9 2004, where 50% regularization is provided to the work charge and casual employees. Now here, Lordship, I have just annexed two small in my affidavit in reply. This is, if to go by that, Lordship, 2004.
Where?
In my affidavit in
When did you
reply, I have filed on Friday.
I don't have it. You have a copy of it? Additional copy?
I don't have extra copy, but
You have it, madam?
Yes, yes,
Let's see. Yes. Anyway, the post is going to get vacant soon.
Yes.
Then,
Lordship,
because
Lordship,
35,
yes.
the respondent number 5 have been appointed, regularized after 31 years.
Yes.
1 year has gone, 32. Another 3 years. When the vacancy arises, they will consider.
30th November 2027.
Then 1 year is left.
Yes, since she is going to retire, Lordship, on humanity ground, I'm also not trying to press on that.
We do one thing. We pass a similar order to the order which I passed in the morning, saying that your claim for appointment on land ownership basis be considered by the deputy commissioner, and then place it before the competent authority.
Lordship.
Whenever there is a vacancy which arises, the deputy commissioner, if it is you have a good claim, the deputy commissioner, the authority will consider you on land ownership basis. That is the only way out. But you cannot be now appointed against that particular person. He has now been regularized. It is again another score. You cannot be brought over. And this court is a person getting after 31 years of service.
Yes.
I am not going to do that.
That was in 2023, Lordship. 2000, now 34 years. So I'm just praying in my small affidavit in reply. I'm just praying that since the respondent number 5 is going to retire on 30th November 2017, my right may not be exhausted, and right after her retirement,
no, madam, that is what I'm passing.
Yes,
That you see,
or even prior to that.
In the meantime,
Lordship.
I am direct you based on oral agreement.
Oral agreement, Lordship.
So your right as to whether you are entitled as per 5/3/2018 be decided by the deputy commissioner.
We have already, Deputy Commissioner, all have given certificate, Lordship.
Have given a certificate.
Yes,
So
Lordship.
then it will be considered whenever the vacancy arises.
Yes.
However, Lordship, the state of the state government is on the basis of land ownership has already appointed Lordship. So in perpetuity, the state will not appoint another
From
person.
their
Lordship.
family.
There are 3 landowners, Lordship.
No.
2 have already been. They also have admitted that I have not been appointed. Yepthomi clan and Chopimi clan.
Where?
In their affidavit in opposition, at paragraph 6. 3 landowners, 19 acres, Lordship. It's not a small plot of land.
So where do they say that you have entitled?
No, Lordship,
Now let us see where the deputy commissioner says that you are entitled to.
Lordship, you kindly see this, here, the client's meeting, 3 clients meeting is at annexure A, page 18.
Annexure?
A, page 18. The 3 clans who donated 19 acres of land for establishment of the orchard, Lordship.
Page 18.
Yes, the 3 clans now, since 2 has already availed, they are willing to let the petitioner
Page 18, annexure A.
yes, annexure A. That is the 3 clans.
Deputy claim and we have no objection in appointing so and so. Who are you? What is your name?
I am a clan, Lordship. 3 clans, Yapami, Chopimi, and Ayemi.
You are
Ayemi clan, the last one on the right side.
You are Chopimi, you are which clan? Ayemi.
Ayemi, Lordship.
And where does the district commissioner say? That
Lordship, kindly, not deputy commissioner, this is additional deputy commissioner.
Where?
Annexure B, page 21, Lordship.
Ah.
Additional deputy commissioner. Who is the additional deputy commissioner of tourism? Under DC.
No. These stakeholders cannot recommend. The recommendation has to be made by only the deputy commissioner. You see, in this regard, the undersigned has summoned all the stakeholders and verified the claim for recommendation being satisfied, hereby recommends so and so for the state post. Also, he has recommended. But hey, can the additional deputy commissioner recommend?
Lordship, in the subdivisions.
Huh?
No, Lordship.
Mr. Santam? You are additional AG.
Yes, Lord.
Can the additional deputy commissioner recommend?
My lord,
In the subdivisions.
Yes, of course. She will get, Lordship.
Huh?
I will get.
Petitioner will get.
If I'm
land falls under subdivision of.
Yes, under the subdivision.
So then the additional deputy
Yes,
commissioner.
ma'am.
can-
Yes, Lordship.
So therefore, this is a recommendation
Yes, Lordship.
of 30th of June 2021.
Exactly, Lordship. DC authorizes the subdivisional additional deputy commissioner to verify, and verification are done by including the customary debashes. The village council's certificate is from B3 to B3, B4. C1 also is
So
there.
then you do one thing. After that post comes vacant, consider the case of the petitioner for appointment on land ownership basis in view of that certificate.
No, Lordship, 2% has already appointed, Lordship.
So then we do one thing. You do one thing that he has given a certificate that
Lordship.
there was an oral agreement. And there is an oral agreement, and in pursuance to that, land was already given. That is a fact which is proved. You consider in the perspective of 3C.
Yes.
As to whether they are entitled or not, and thereupon consider the case of the petitioner. 3C is on the question of perpetuity.
Lordship.
So you take a decision as to whether it would be a case coming under that a mischief of 3C. If mischief of 3C comes in, and therefore the petitioner herein is not entitled to an appointment. And if the mischief is not there, appoint.
Lordship.
Good for both.
My humble submission, Lordship, if my Lord will kindly peruse only this, page 28, D1, that is map. This is a Government of Nagaland Department of Land report and survey. Map, this will speak for itself. The learned government advocate is saying that we have availed to appointments. However, this is pertaining to 3 clans donating 19 acres of land, Lordship. And I have 6.5 acres donated here. I have never availed even one appointment. So this is
Okay, don't worry. I'm passing the order.
Lordship.
Heard Ms. Z. Zimomi, the learned counsel, appearing on behalf of the petitioner. Ms. So-and-so, who appears on behalf of the respondent numbers 1 to 5, 1 to 4.
1 to 4, Lordship.
None appears on behalf of the respondent number 5. The petitioner herein has approached this court, being aggrieved by the non-consideration of the case of the petitioner for being appointed as a multitasking staff in the district, in the establishment of the respondent number 4, isn't it? 4, huh?
Yes, Lordship.
In the establishment of the respondent number 4, in terms with the notification dated 5/3/2018. It is also the case of the petitioner that the respondent number 5 was regularized to the said post, and thereby depriving the petitioner's right to be appointed in terms with the notification dated 5/3/2018. The brief facts as it appears from the materials on record are that in the year 1975, an oral agreement that in the year 1975, in pursuance to an oral agreement, the Chopi clan, Yotomi clan, and Aemi clan from Vekuhoho Old and Vekuhoho New villages donated their plots of land for establishment of the, what is AHF? Agricultural?
To establish
AHF in consideration of AHF.
Atoizu Horticulture Farm, Lordship. Atoizu Horticulture
Farm.
Farm. In short, AH.
Gusto. It was agreed at that point of time that appointments would be given to the persons, to the families of those persons, to the families of those clans who have donated the land. It is the case of the petitioner that amongst the 3 clans who have donated, the Chopi clan and the Yotomi clan have already availed appointments. However, the Aemi clan, to which the petitioner belongs, did not avail any appointment. First, in that regard, the petitioner, the counsel for the petitioner have referred to the minutes of the meeting of the 3 clans, wherein it was resolved that the Aemi clan should be given an opportunity for the post of Mali vacated by the death of late Hekuba Itomi, who expired on 17/6/2021. The petitioner also submitted an application claiming the said appointment in terms with the notification dated 5/3/2018, and the said application so filed was also recommended by the additional district commissioner. Atoi Zoo, Nagaland. To the Director of Department of Horticulture. The grievance of the petitioner is that the petitioner, that the application of the petitioner was not considered, whereas the respondent number 5, whereas the post was filled up, the vacancy was filled up by regularizing the respondent number 5, thereby respondent number 5. It is under such circumstances the petitioner had approached this court by filing the present petition. The record reveals that the respondent authorities have filed their affidavit in opposition. In the said affidavit in opposition, it is mentioned that the respondent number 5 have been working as an MPS casual for nearly 31 years. And as such, she was entitled for regularization against the vacant post in terms with the office memorandum dated 22/9/2004. It is also mentioned that the respondent number 5 having served nearly 31 years as on 2023. She was regularized in terms with the office memorandum dated 22/9/2004 and 17/3/2015. In addition to that, it is also mentioned at paragraph number 6 of the said affidavit in opposition that the petitioner herein is not entitled to claim ownership on land, claim appointment on land ownership, inasmuch as it is the very case of the petitioner at paragraph number 3 that employments have been availed by the Yotomi and the Chopi clans. And in terms with clause 3C of the notification dated 5/3/2018, employment to landowner in perpetuity is not the policy of the state. It is noticed that in pursuance to the said affidavit in opposition, a reply has also been filed by the petitioner, wherein it is mentioned that there were 3 clans who have donated the land. The clan of the petitioner had donated around 6 acres.
Altogether, 19.90 acres.
How much did you donate?
That if divided into 3, it will come to 6 acres and
had donated almost 6.5 acres of land. It is the further case of the petitioner in the said affidavit in reply that the AHF, the full form I have given, is established on a plot of land which is around 19.5 acres, which were donated by the three clans, namely so and so, so and so, so and so. And the petitioner's clan have not till date availed any appointment.
Exactly.
It is also stated in the said affidavit in reply that as the respondent number 5 would be retiring on 30th of November 2027, as is 2027, in terms with the Nagaland Retirement from Public Employment (brackets Second Amendment Act 2009. The case of the petitioner should be considered for appointment on land ownership basis against the vacancy which would arise then. This court have heard the learned counsels appearing on behalf of the petitioners, on behalf of the parties, and have also perused the materials on record. The challenge, the grievance of the petitioner herein is for two reasons. First, non-consideration of the petitioner's claim in terms with the notification dated 5/3/2018 in respect to the post which fell vacant upon the death of so and so. Death of death of late Hekuvi.
Yes, Lordship.
Hekuvi. The second grievance of the petitioner is the regularization of the respondent number 5 to the vacant against the vacancy which arose out of the death of late Hekuvi. It is relevant to take note of that in the state of Nagaland, the government of Nagaland have formulated various schemes, various policies for granting appointment as well as for regularization. The notification dated 22/9/2004 is a notification for regularization of work charge,
Work charge and casual employees.
and casual employees against vacancy which arises.
General vacancy.
The office memorandum dated 17/3/2015 is for regularization of work charge and casual employees who have completed 30 years of service and was on the scale of pay. In the case of appointment, a regularization in terms with the office memorandum dated 17/3/2015 the regularization, I'm sorry, the employee is regularized by creating a supernumerary post personal to the employee, and upon his or her retirement, the said supernumerary post ceases to exist. The government of Nagaland also has a policy for granting appointment on land ownership basis in respect to those written or oral agreements which existed prior to 26/7/2005, wherein lands were donated and promises were made by the state or its representatives for representative to grant employment to the family members of the donor. In the instant case, in the backdrop of the above, if this court now takes note of the facts in the present case, it would be seen that the respondent number 5, who had rendered service as an MTS casual for nearly 31 years, was regularized against the vacancy which arose on account of the death of late so-and-so. The same having been done in terms with the office memorandum dated, it's a notification office memorandum 22/9.
Office memorandum.
Office memorandum dated 22/9/2004. The question of interference with such regularization of the respondent number 5 does not arise. Be that as it may, the claim of the petitioner is on the basis of the office of the notification dated 5/3/2018. From the materials on record, and more particularly the recommendation made by the additional district commissioner, the deputy commissioner. The name is Artizuro or something. What is the name? Additional deputy. Which place? It appears that there was a recommendation made that the petitioner should be granted an appointment, should be considered for appointment, as the petitioner belongs to one of the clans who have not availed any appointment. The respondents, however, in the affidavit states that 2 of the clans who have donated the land have already availed appointment. The petitioner also do not deny to the same, inasmuch as the same aspect is apparent from Annexure A to the petition itself. The question, however, arises as to whether the petitioner's clan would be entitled to avail the opportunity of employment, having donated some portion of the land for the establishment of the AH so and so. AHF. What is that? AHF.
Although it's a horticulture farm.
This aspect would require a consideration on a factual aspect as to whether the petitioner's clan have donated any land and is it only and donated any land and whether the claim of the petitioner's clan is independent of the claim of the other two clans, namely so and so and so and so, Chopi and other one. No?
Which 19 is there, Lordship?
First. Accordingly, this petition therefore stands disposed of with the following observations and directions. The challenge to the regularization of the respondent number 5 by the respondent number 5 by the order dated 17/1/2023 is rejected. Number 2. The respondent number who will do it? You have not made the deputy commissioner a party.
Lordship. Addition.
ADC also not party.
Actually, Lordship, it is the respondent number 4 who is the appointing authority. And the extra assistant commissioner has already, if my Lordship is talking about verification, that is on page 29.
The respondent number 4 is directed to consider the materials on next number 2. From the materials on record, it appears that the respondent number 5 is going to retire on 30/11/2027. A vacancy thereupon being created. This code directs the respondent number 4 to consider the case of the petitioner for appointment in terms with the office member notification dated 5/3/2018. It is observed that in the circumstance, the deputy commission, the respondent number 4 requires any factual adjudication as regards the claim of the petitioner. The respondent number 4 shall obtain the necessary inputs from the district commissioner, from the deputy commissioner, Junebato, Nagaland. Junebato?
Lordship, Junebato.
Junebato, Nagaland. Push. This court further observed that while doing so, while considering the case of the petitioner, the respondent number 4 shall also give due regard to the communication issued dated 30/6/2021 by the additional deputy commissioner Erudju Nagaland to the director Department of Health, the Horticulture, Nagaland. We should not give you, we don't ask the person to the deputy commissioner, let us not go. Well, considering, shall consider in terms with this. I think then you will get it.
For admission, item number 12.
Yes, Mr. Santam.
My lord, I'm yet to receive instructions. However, the present petitioner is a police personnel who was also implicated and arrested in connection with NTPS Act. NTPS Act. He was arrested in connection with the NTPS Act under Longland Level PS. As of date, departmental inquiry is still going on.
Going on?
Yes, madam.
Finished?
It's still going on. Departmental inquiries.
Good. Completely. When you are completing?
My lord, I may be granted 3 weeks time
For what?
for obtaining instructions.
His only prayer is
Yes,
that
ma'am.
don't have the departmental proceedings at the time when we are having the criminal proceedings. His defense is here. But that case is, this case, I think, is 99 Paul Anthony, then you have the Stenzen judgment, then there is another judgment of, recent judgment of Vishwanathan. These are judgments which are there where it says that if it is, it can still continue.
Yes, madam.
So
Yes.
those are judgments, but you are trying to make his repetition infructuous.
My lord,
Isn't it?
suspension doesn't
As
mean.
per my information, the inquiry has not been conducted. I mean, as far as the petitioner is concerned, he has filed his written statement to the memorandum of charges. But after that, no proceeding has been initiated insofar as the inquiry is concerned.
My lord, the objective of taking up the departmental inquiries is to ascertain the fact whether or not.
No, I understand, but you have not done anything. You are trying to make his petition infructuous by not filing your affidavit. One last chance.
Yes, my lord.
One last chance. Else we are going to take up the matter without your affidavit.
My lord, I may be granted 3 weeks time.
No. 2 days. 5 weeks.
May
It is
pray
seen
that
that
3 weeks time. may be
it
granted.
is seen that this court had issued notice as far back as on 7/8/2025. And it is being submitted by Mr. L.T. Santam, the learned additional AG, that till date, even after a passage of more than 7 months, no instructions have been provided to him. So it appears that either the state do not want to avail the opportunity of bringing on record their stand, or the state is not bothered in the instant proceedings. It may not be out of place to mention that the petitioner herein, the case of the petitioner herein is that the departmental proceedings should not be, that should not be, it is the case of the petitioner herein, that the parallel proceedings of departmental proceedings and criminal proceedings, that there should not be a parallel proceedings of departmental as well as criminal proceedings. The filing, the time which have been taken by the respondents to file the affidavit appears not to be in good taste, as the petitioner, as the good taste, thereby trying to render the instant repetition infructuous. Considering the above, this court observes, grants a final opportunity to the state to file the affidavit on or before 24/2026. List the matter on 24/4/2026. It is observed that in the circumstance no affidavit is filed on or before the next date as stated above, this court shall either take up the instant writ petition for disposal on the basis of the materials already available on record, or may consider passing of interim directions.
For admissions, item number 13.
Your Lordship. Your Lordship. Yeah, I've sent the affidavit for vetting, Your Lordship.
Ms. A.M.A., the learned counsel appearing on behalf of the petitioner submits that the affidavit on behalf of the state respondents has been sent for vetting. It is also seen that the notice was issued as far back as on 12/8/2025, and 7 months have in the meantime elapsed. A final opportunity is given to the state to bring on record the stand by filing the affidavits on or before 27/4/2026. List the matter on 30/4/2026.
For admission, item number 14.
Lord, I may be permitted to appear through online.
Yes.
Lord, this matter may be taken up after 2 weeks. I have to file rejoinder. The signatory is out of the country. But I request only 2 weeks time on filing rejoinder.
The counsel appearing on behalf of the petitioner submits that some time may be granted to the petitioner to file the affidavit in reply to the affidavit filed by the respondent, numbers 1 to 4. First of all, let this matter be called up again on 27/4/2026. In the meantime, reply be filed on or before 23rd/April/2026.
Obliged, my lord. Obliged.
For admissions, item number 15.
Lordship. Lordship, here I need to receive instructions, so kindly grant 3 weeks time if I'm with them.
How much time?
Lordship, 3 weeks time, Lordship.
Counsel appearing, Madam, you have earlier also no instructions. Same.
Lordship.
Is it that you got scared with the number of counsels out there for the petition? Not 1, not 2, not 10, not 12, not 15, 17 counsels. Huh? 17 counsels for how many petitioners? Let us see.
8, Lordship.
Okay, 8. So 2 counsels each. The counsel appearing on behalf of the state respondent 6 for 4 weeks' time to bring on record its stand by filing the affidavit. It is noticed that on the earlier occasion also time have been sought for. Accordingly, this court therefore grants a final opportunity to the state respondents to bring on record their stand by filing the affidavit. This the matter on 18th of May 2026. Affidavit be filed on or a final opportunity to the state to file the affidavit on or before 11th of May 2026.
For admission,
I pledge.
item number 16.
May please, Lordship, Lordship, 3 weeks then may be granted to me to file affidavit.
3 weeks' time. What is the matter, Mr. Dimami?
My lord, I am the chairperson of the Dimapur Municipal Council. I effected a reshuffling of portfolios that was interfered with by the state.
But does the state has any power?
No, then. No.
In view of Article 243 M1. The state wants to file affidavit. Who is appearing for the Naga?
Private respondent is also present. DMC, no one is. DMC is not a party, my lord. Just the state and the private respondent.
Who is appearing for the Dimapur Municipal Council?
No. You're waiting for the state.
Lordship, I'm for the state,
You are appearing for the state.
Yes,
Who
yes.
appears for the Dimapur Municipal Council?
DMC is not a party.
Not a party, CEO, he is an state government, your Lordship.
Understood. The Chief Executive Officer, Dimapur Municipal Council, who is
He's a
appearing?
He's a government employee.
He's a
He's the
government employee.
So you are
Yes, representing him.
Ms. So-and-so, the learned additional advocate general, appears on behalf of the respondent number 1, 2, and 3.
And
Mr. So-and-so appears for the respondent number 4. The learned counsels for the respondent seeks for an further opportunity to file the affidavit in opposition. First up. List this matter again. How much time?
3 weeks, your Lordship.
3 weeks, let us make it 6 weeks. This is matter on 19th of May 2026. Affidavit be filed on or before
Lordship,
13th May 2026.
sorry for interference, but Lordship make it prior to come on. Yes, Lordship, because there is an urgency in this matter, because
When there is an urgency, you should have. There's an interim order operating.
so Lordship make it 3 weeks, your Lordship.
An accommodation for filing the affidavit. It is also submitted that the matter is urgent. Accordingly, list this matter on 24/2026. Affidavit be filed on or before 10th of April, on or before 8th of April 2026. 8, you can file? Because we have to give liberty to him to file reply.
Yes, my lord. Their urgency means they're going to bring some ammunition against me.
It gets 15, on or before 15.
On or before 15th of April 2026. List the matter then on 24th, huh?
Okay, Lordship.
24th April. Affidavit be filed on or before 15th of April 2026. Liberty given to the petitioner to file reply on or before the next date. The interim order passed earlier on 19/2/2026 shall stand extended till the next date.
For hearing, item number 17.
Now, Mr. Sharma, what did you think?
My lord, it is not a case. If it is the case, actually the Telugu village filed a suit for declaration of their title interest in respect of 300 acres of land. 300 acres of land. And they got a decree. And they are in possession of the land. Out of that 300, they gave us 100 acres of land.
When did they get the decree?
1979. 1979. donated the 100 acres of land to us.
But Mr. Sharma, if the land has already been declared to be a reserve forest in 1916, how can there be at all a decree?
Maharaj, that is the point, because here in this case, the chief conservator of forest and other forest department, they adduced evidence, and they have stated that originally there are 400 and something hectares of land under the Nagaland forest area. And in his evidence, he also stated that at present 76 hectares are in the possession of the forest department. Therefore, the remaining land is occupied by some person.
No, but then also it cannot be. There cannot be a decree, there cannot be a declaration, nothing can be done till that particular notification remains.
I am claiming title declaration of my right title interest from the Telugu village, defendant number 6.
No, you ask from Telugu village, whatever, but you cannot have anything to do with the state. The state, under no
No,
circumstances.
state I have made party because.
But no, Mr. Sharma. Mr. Sharma, you have to see the suit. You are not asking the declaration from the respondent number 6. Respondent number 6 is a performer defendant. Then you are asking the declaration from the state.
Because state is
The entire suit is misconceived.
No, why I am claiming declaration in prayer number 1 is this. When I am in possession of the land, the forest department issued a notice to us that stop construction and stop cultivation. Against that, we filed a writ petition. And the writ petition was heard.
And how much land? 1,000 acres.
100 acres.
Delivery of khas possession of the scheduled land by evicting the defendants their men, to appoint a survey commission to demarcate the boundary, to grant the permanent injunction restraining the defendants and from disturbing. None of these reliefs can be granted.
No, Manoj, the whole thing is this. The government issued a notice to us. Stop construction and stop cultivation. Against that, we preferred a writ petition. And that writ petition was disposed of and directed us to file a civil suit. Then where is the wrong?
So
I filed a suit.
Understood. Filing a suit, you can do anything. That is why a civil court is there. You can file any suit. There's no quarrel with the proposition that you will file a suit. You can very well file a suit. But the fact remains as to whether your suit, without a challenge to that notification, has any maintainability. And more particularly, when you file the suit in respect at a time when the Forest Conservation Act has already come in. And the Forest Conservation Act applies to the state of Nagaland, and by virtue of Section 2, there cannot be a declaration given under no circumstances. It is only to be done only by the central government.
That is done by the Nagaland government by issuing land to the different departments, different villages, and villages got recognition from the government, from the forest land. Initially, whole Nagaland is a forest land.
No, I'm not concerned with whole Nagaland or anything. I'm concerned whether your land falls within that notification of 1916. Yes, it falls. Matter ends there. The fact that if you are filing the suit in the year 2003, your declaration also has to be sought against the central government in view of the Forest Conservation Act. There's no way, this is a law well settled. 1980, there, that Section 2, there, even the state or anybody cannot give a declaration to that effect that unless you challenge that notification. And there cannot be an existence of any person out there unless you come within the ambit of the Scheduled Tribes and Forest Dwellers Act of 2006 and apply as per that. That is the only way out. Therefore, I said on the last occasion that you have the liberty to ask that. That is another thing. But here, asking this is impossible.
What happened is this. where the Reed Court has directed us to file a suit
The
and get
the Reed Court must have done so on the basis that why should I spoil the time on this?
ultimately
So that-
ultimately the party will suffer.
Absolutely, it has suffered. But the fact that the court, in fact, that the sad part about this matter is that on the date on which the suit was filed, they should have filed an Order 7, Rule 11 and gone for rejection of the claim. This should have been done on the first date itself.
But they did not.
They did not. The court also went into it by framing 1819 issues. Then also, here also, the sad part is the learned coordinate bench also has remanded on another issue, which was not relevant also.
But what we will do when the court has issued a commission to find out the whether recognition is, we are helpless.
Understood, you are helpless, but the fact remains that you under no circumstances the decree can be passed. Impossible. Only way out. That is why I said, Mr. Sharma, on that day, consider about what to be done in terms of that act under the 2006. That is the only way out. There's no other way out. When it is a reserve for it. Now, if you see Section 4 of that Act of 2006, it's a very interesting aspect. Read Section 4. Irrespective of
Section 4 of
the 2006 Act.
Yes. Recognition of vesting of forest right to the dwelling scheduled tribes and traditional forest dwellers.
Notwithstanding anything contained in any other law. That is how it starts.
Notwithstanding.
And thereby even takes care of. Well, it is there in what you call takes care of the Forest Conservation Act. This is the only way by which you can ask for being a scheduled tribe. As I said that day, you and me will come under the forest dwellers, and thereby we have to show 3 generations. But a scheduled tribe need not. Scheduled tribe has to file an application before that. Now, this is, if you see the objection reasons of this act, are very beautifully why it was brought in. It is say that while making these reserve forests, it's a very interesting concept of reserve forest.
Yeah.
Why you have the word reserved? Can you tell me? Why they have the word reserved? Because at that point of time, the British, when they were concerned about various, they needed logs or wood for the purpose of carrying out or taking steps for the purpose of the railway construction and all these things they needed. So then the British at that point of time reserved these forests. And therefore the name came about reserved. And that is done for themselves. So here this act therefore categorically say that there has been historical injustice to those people who have been the forest dwellers, the ST people. Because you have to understand that scheduled tribes, scheduled caste is different, whereas scheduled tribes. Scheduled tribes are more affiliated with the forests. As I was dealing with the judgment in the case of the state of Mizoram, versus that, in that case also, 88% of the people are scheduled tribe. Oh no, not 88, 92, 91, 92%. 88% of the people are of the area is forest in Mizoram. Now with 88% and 98% is the total ST. Where will these people go? You have to give them the rights, somewhere they have. So therefore, they will obviously have the rights whether you make it reserved or not. And therefore, although the act came in that case, although the awards were passed in the year 2001, 2002, but the act came in 2006. Therefore, but it says, notwithstanding anything, even it takes care of the Forest Conservation Act. Otherwise, the Forest Conservation Act is the main problem which you have. This decree cannot be granted. Impossible.
No, my lord, in that case, my lord, I may be allowed some time to.
That is why I allowed time.
More time to.
Okay, I'll give you 5 minutes time. Let me come down.
No, 5 minutes.
5 minutes. What is there? No, Mr. Sharma, this is a case which should not remain any further. And later on, as it happened from you only, it has come up from your mouth. Then why did the court out here at the first instance directed you to go and file a suit?
No, but I am not on that one.
No,
And
and then
I-
thereupon, the court having filed a suit, and you filed a suit, then on this matter come up before this court out there, the suit you filed, the suit got dismissed, the appeal filed here, it was remanded under Order 41, Rule 25, again came back, now this has happened out there. So where will the petitioner? The only way out is that.
That is why, my lord, I also gone through the actual what is what. And my lord, I also take some inform my client also. Because if we want to withdraw, then he.
You don't need to withdraw, we dismiss it. We dismiss it because the suit is misconceived. The suit is misconceived.
In that case, my
The
lord,
trial court has been very kind enough to write such a long judgment.
Lordship, as per the record, the learned trial court has framed 9 issues. And the Honorable Appellate Court has, on the direction of the Appellate Court, another issue was framed.
As to whether the plaintiff could file the suit on its own.
No, not on that. That subsequent issue was whether the plaintiff village, namely Telugu PU village, was formed as per the prevailing customary law and recognized as per the norms as applicable in the state of Nagaland. So that it was a last issue. And most of the issues were decided against a appellant. The record itself is very clear. Apart from all those
No,
other
the thing
issues-
is, it is not a recognized village. It
No,
may
no.
not be a recognized village as no, Mr. himself. It may not be a recognized village in terms with the Village Council Act, because Village Council Act only has the concept of a recognized village. It may not be, but the fact remains, whatever may be, whether the petitioner can file a suit on its own. Now here it is being filed by a village represented by its village head, GB so and so, resident of so and so. Now village head, a suit being filed by a village. Yes, the suit otherwise is permissible. I don't think there's any problem with that. Yes, it may not be a recognized village. I think that person should have filed.
But that judgment we have.
Lordship, here, whether it's a recognized village or group of people or individual, doesn't make any difference. Lordship.
Huh? Why should we go into that?
Yeah.
Those trivial issues.
No, but the judgment, my lord, the is High Court observed. BP কত গেছে
Okay then, Mr. Sharma, tomorrow 2:00.
My lord, the
No, Dimapur nearby. This person is in Dimapur. You wanted to take instructions on to withdraw or not? Or we passed to either to dismiss it or what it may. I think this is a case for dismissal. There's no worry. There's no quarrel with that. And you see, the suit has been also not properly done. No Section 18 notice also. Although no issues have been framed to that effect. It would have been a wonderful case for this. But now you want the dismissal on Adikitari? 23rd.
23rd.
On 23rd or 24th, whichever I can give you that. When the person is in deathbed.
My lord, 23rd or 24th it may be. but not in the month of March. Any other month.
No. Day or tomorrow. Or we can put it, would you like to do it in 1 hour or in the next 24 hours?
Fact remain the same. Whether we postpone.
But I think we finish it up, Mr. Sharma. There's no.
My dear, your lordship, my lord, I am agree with your lordship, but
No, I will give.
but keep it parted.
No, it is not parted. I'm not going to stay here. I'm not going to come for the next 6
No.
months.
Because it is listed as part, it may be kept as part.
Why should I? It is not necessary. People will love to keep a part of this type of matter. This is Mr. Sharma, you also know.
Yeah, I know.
You are one of the in Gauhati High Court, you are the principal seat, you are the most prominent civil lawyer. You also know where you stand here, Mr. Sharma.
No, I am nothing know about the civil law. My prayer before your lordship is this. I am agree with your lordship, what your lordship is.
You think over. I can do it within 24 hours. You just think over. What can be the best thing I can give it to you with a dismissal? Can I give an observation that you can approach under the 2006 Act? Think about that. That is the only way out. That is the only way out. There's nothing else. Because if it is a reserve forest, under no circumstances you can.
But if your lordship go through the evidence of the conservator and others, forest officer, there is no reserve forest at that time, at the present time, because 478 hectares of land was reserve forest. And
Mr. Sharma, tell me one thing. Whether the notification of reserve forest was brought on record? Yes. Whether it is mentioned in the written statement? Yes. Whether the declaration that it is a sanctuary mentioned? Yes, in 1987. Now you filed the suit in the year 2009. How can you have any relief be granted? And any relief would be granted would be dehorse the proceeding, the Forest Conservation Act. Impossible. We come back and finish it off today itself. I'll come back in 5 minutes. We'll finish it.
You cannot class it.
Yes. He got to say he have a prayer for us and something about problems every year.
Oh, name. I didn't hit him.
I mean, only for this, yeah, but recognize or not, it to point to say among Supreme Court. We are separately filed a memorandum of ethics on this point.
My lord, I pray that it may be taken up tomorrow.
Tomorrow. This is the matter tomorrow. At 2 p.m.
If it is assumed, it will be far better for us.
Tomorrow at 2 p.m. Today the sun is there. Tomorrow you never know. Kohima's weather is very unpredictable. Tomorrow it will be done.
For hearing, item number 18.
What? Personal difficulty. He has not arrived till now. The road's so bad. He appears for NHIDCL. He should stop appearing from them. From coming from what you call Dimapur, Mr. Phom, in the morning only, at around 11 o'clock, she said he's coming. Till 3:30, he has not reached. Chalo. Here it is saying no further adjournment shall be granted. You are appearing for whom?
Santiago petition.
He is for the other side. Who is the petitioner?
I'm the petitioner.
You are challenging what?
Then, my lord, let the matter become up tomorrow.
Tomorrow I got many matters. One matter is there. Tomorrow this matter.
Thursday, then, my lord.
I'll still know that. But I'm not taking up any criminal matters. Why the matter, criminal matter is before me? Counsel appearing on behalf of the petitioner is not available. Considering the above, for the ends of justice, the matter stands adjourned to be listed again on 2nd of April 2026. No further adjournment shall be provided on the next day.
Much obliged.
For hearing, item numbers 19 to 21. I beg your pardon, 19 to 22.
What are these?
May I please, Your Lordship, this is an appeal against the impending judgment and order dated 23-1
Why three matters are together?
analogous matter arising out of the same accident and common judgment was passed.
So what is your ground?
Your Lordship, I'd like to take Your Lordship to
You are for the insurance.
for the insurance company,
Why
United
are you
India Insurance.
excluding it?
Lordship, there was a two vehicular accident. The accident was arising a collision of two vehicles, and one vehicle was not impeded. That is one ground. The other ground is the claimant has filed under section 166 of MV Act. Under one section 166 of MV Act, the claimant before the trial court. However, ration and negligence has not been proved. This is my other ground. And my third ground is the learned tribunal has considered a sketch map. Basing on that, they have come to the conclusion that the vehicle was in rash and negligent manner. However, the sketch map was sketched by the one of the claimant, Your Lordship. This is my other ground, Your Lordship.
Who is paying for the other side?
I am appearing for the primary respondents in all the analogous cases.
Mr. Counsel, we may have to interfere with this order and direct it, remand it back for a decision on the question of by framing an additional issue as to whether there was rash and negligent driving. There was no issue framed.
Yeah, the question of negligence shall be decided as per the evidence adduced. Sufficient evidence are there.
Where is that? But there is no issue framed. No problem lies there, Mr. Counsel. Where is the issue framed? Show me. See there at page number 16. Now page number 16. Huh? Page number 16, where is the issue?
Kindly see MEC 28 2014 will be taken as a lead case.
20?
MEC 28 of 2000.
No. Here I have three appeals.
Here in the appeal.
No, Mr. Counsel.
Here in the appeal,
Which appeal you are referring to?
MEC appeal number 13.
13. Yes.
The learned member of the tribunal is squarely digest the evidence. Because it is a matter of trial and evidence, not a writ petition.
No, Mr. Counsel.
It is a matter of trial and evidence. So
No,
pleading and evidence
No,
will
Mr.
be
Counsel,
used.
you have to understand first and foremost. There is a requirement of, you see, there is a difference out there. When it's a case under 164, there is no requirement of proving negligence. But when it's a case under 166, a question of whether there was negligence is a question which needs to be proved.
Negligence and joint parties has been clubbed together in the first issue. Issue
Let us
number
see.
one.
Issue number one is whether the claim petitions are bad for non-joinder of parties and as to whether the there was were involved in the accident dated and if so, whether the claim petitions are maintainable. How can there be that be said to be an issue pertaining to negligence? Show me the finding. Show me one finding of the learned trial court that there was a negligence on the part of the offending vehicle. Show me that. Matter over.
The question of negligence was decided in issue number 1.
Let us see where. Issue number 1, let us see where is the finding. The tribunal perused the documentary and heard the arguments and appearing and decided the issues as follows. Issue number 1. In claim petition number so and so, so and so, so and so, stated the cause of is the sole negligence of the driver of the area. No evidence have been brought forth which may prove or can infer any negligence on the part of the driver of the so and so. It can be observed from the site map and that the process of negotiating the sharp card towards the so and so was occupying the sharp entire space of road meant for so and so coming into from the opposite direction had no space to evade the bus as there was a steep slope on the other hand. Even in the accident report, there is absolutely no mention of the Maruti Gypsy. Knew the bus was the offending vehicle. Hence, there is no non-gender of parties so and so, so and so. Hello?
Lordship, in this case, one of the vehicle involved in the accident, the sole surviving victim of the accident is the claimant in MECFL number 16 key of 2021. 16 key of 2021. The claimant herself is the surviving victim. The rest all died. So her evidence is very clear regarding negligence, proof of negligence. So this may be taken up by this honorable court. Question of remanding the case for the trial does not arise. When evidence is sufficient evidence is under the report. The question of sending it for retrial does not arise. So Lordship, can you see the evidence of the claimant, sole surviving claimant in MEC Appeal 16 key of 2021, which is arising from MEC case number 112 of 2014.
So these are the two grounds.
Lordship.
One is negligence and the
Negligence, the
other.
other one is the learned tribunal has taken in consideration of the sketch map, which was prepared by the own claimant himself. And taking into consideration has come to the conclusion that there was rational negligence. However, it was not proved because the charge sheet is also not filed.
Well,
Even in a
criminal trial.
police report, Your Lordship.
Criminal trial is nothing. It is a civil trial. It is a total just liability, not a criminal liability.
Even in a police report, it only says that all action has been taken and now case is pending for submission of FF. Now I was also not examined to prove rational negligence, Your Lordship.
The surviving witnesses already deposed the evidence, sufficient evidence. The police is they are the third parties.
Where the records of the case?
Can you see this statement of the evidence of the witness, number 1, the claimant, in MEC Appeal 16 key of 2021. She is the eyewitness. She was present in the vehicle. She was one of the occupants of the vehicle involved in the accident. And she is the only surviving occupant.
She is the claimant herself.
So this evidence cannot be override by any other evidence, secondary evidence. There shall be no period evidence than the evidence of PW1 AMC 112 of 2014. As per the evidence say. There shall be no other video evidence under the law. Well, should be kindly along with the bureaus the evidence of this
No,
witness.
no, these are criminal proceedings. Where is the records of these cases? There's no records.
LCR, no courts in courts.
LCR not called for. Oh, goodness.
LCR has not called for.
It's
What I said.
Hello.
You know how it came to the hearing stage.
LCR has not been, because it is listed for hearing in an order of 2023. We do one thing.
Of course, it is a very old case. The claimants are not yet compensated. When the breadwinner of the family expired long before, more than 10 years now.
No, it's okay. Now we do one thing. Taking into what submission he has made.
Of course, Lordship, this Honorable Court also having ample powers to formulate issues regarding negligence in addition to issue number 1. Issue number 2, may be framed by this Honorable Court and look through the evidence so that it can easily dispose of the matter by the best evidence under the court. There is no harm. The appellate court has ample power.
Now I can frame an issue. If I frame an issue, then can I decide it under Order 41, Rule 24?
Lordship, it has ample powers.
Documents are there, then only I
If
can.
there is no evidence, retrial will be directed, of course. But evidence already recorded on the question of negligence.
We do one thing. Let us frame one additional issue. And let us call the records and see as to whether these additional issue can be decided on the existence or on the basis of already the materials.
Yes.
Now,
Yes.
in the circumstance it is not possible, then we can exercise our powers under Order 41, Rule 25 by keeping these appeals pending and asking them to produce asking the trial court to record evidence and then to do it. That is a subsequent course of action. Today, the materials on record shows that there is a case of negligence as from the order that the offending bus there was a case of negligence because there is an evidence given to that effect that this car was stopped, the gypsy was stopped out there, whereas the bus did not put the brakes and the gypsy could not move to the left because there was no space,
No space at
otherwise
all.
it would fall down.
Yes, Lordship.
So we do one thing from the discussion. It appears there is a decision on the question of negligence being looked into. But however, there has been no issue framed. So we do one thing, we frame an issue at the stage now and then call for the records and look into it. Can that be decided in terms with Order 41, Rule 24?
Yes, Lordship. That would be the correct procedure.
Chalo.
Wonderful.
Oh, records are where? Records are here. Let us see one of these. Records are here.
Lordship, even on writing the judgment, the appellate court has ample power to bring issue, not necessarily to make a special hearing on this matter to the councils. If any difficulty is found by the honorable court, this honorable court has ample power to frame the issues in record finding thereon.
Mr. Counsel, do you have a copy of the claim petition?
Sure.
Let us read the claim petition at page of MAC case number 28.
Lordship, paragraph 8 of the claim applications are analogous because this is in the format. So paragraph number 8 provides place, date, time, and time of accident and how it occurred with brief description.
You give a copy, give that to him. Yes. Read it.
Yeah, right.
Kindly see the page 4, the third paragraph. However,
Lordship.
However, on the way, it was about 100 meters away from Dimapur from Gautam Bosti junction so and so. In a sharp curve of the road towards the left, the bus bearing which was originally reached as owned by so and was driven, which was coming from the opposite, came by the wrong side of the road, occupying the entire road, meant for the opposite coming by and hit the rear. Wouldn't this constitute a rash and negligent driving?
Lordship, this is the version of the claimant only.
It's okay.
Lordship.
So it is not that there is no pleadings.
Lordship.
Now kindly come to your written statement. which was
Written
filed.
statement was filed by the owner driver of the vehicle on bus, offending bus. So that is relevant. He have not denied it. In the written statement.
Mr. Counsel, kindly come to paragraph 8.
Lordship. The May I read, Your Lordship?
Beg to state that the accident is a result of involvement of two vehicles and the result of contributory negligence on the part of the Maruti Gypsy, which was lying in the road in violation of, were plying on the road in violation of the motor without having proper insurance coverage of the occupant of the vehicle. The answer in denies that the vehicle stated to have been insured with so and so was at fault. So here, this is being stated and this is being denied. Bhargavi,
Lordship.
there is a denial.
Partially.
There is a denial that there was no fault on the part of that person. Now, although the CPC does not apply to the motor vehicles tribunals, but it is the spirit of the CPC is being taken. But the facts are pleaded that the vehicle in question, the road was not this much. The vehicle, the bus which was coming, came up in such a direction, taking the entire road on the wrong side, and it was there. You denied it. So the question is, there should have been an issue framed, but however, the issue was not framed. Now let's see the evidence, how it is being taken. The evidence shows that did you adduce evidence?
Lordship, on behalf of the company, Lordship?
Yes.
Lordship.
Insurer. Now, kindly see the issues which were being framed. Evidence on chief of the PW1, so and so. He says that I said I am the daughter of so and so. I am the deceased. I was long Iman. That on Iman, my deceased daughter, accompanied by my wife, started to journey and so and so. I on the way on my year started here, was traveling to Sweden, owned by the women and so and so. There was nearby so and so, and my original registered as so and so, which was coming from by the wrong side and so and so. I saw that there was a road divider in the white beams all along the road. However, while negotiating the bus took the space of the road meant for the area. This is the paragraph 6 and 7 of the plaintiff evidence. Now, kindly see the insurer's cross. It is correct to say that I am not the eyewitness to the so and so. I have deposed so and so. It is correct to say that my wife does not swear. I deny that my so-and-so can or does have work. I cannot say as to how my daughter was traveling by the gypsy. It is correct to say that I have not furnished any document to show that I am the legal heir. I am a government employee. I deny that there is no loss of so-and-so. I deny that amount. Now, you did not put a single question on this.
Yes, this statement was not in page.
Now let us see the deposition of DW1. When I am the branch manager of so and so, I am deposing and bringing away reports of the year as per the records of the accident at Gauhati involving two vehicles as so and so insured by so and so. As well as the accident is the result of involvement of where there is no police record to prove that the insured was the offending vehicle. The record available to the company also do not reveal that the driver was charge sheeted by IA as per so and so, so and so. In so and so, proper income proof has not been furnished. I relied on the accident information exhibited as so and so. Manager United so and so. Involving two vehicles, the insured as so and so. I confirm the policy number so and so, DW1, by the Golagat branch in so and so. I relied on the document of the insurance import exhibited as Exhibit 7 and its contents. Written argument. Evidence information, the government insurance company, insurance, Evidence taken report does not give anything. And Mr. Counsel, who were the insurers, who are the persons who have given evidence in all the cases? Now it is your turn. Who are the persons who have given evidence?
All the other witnesses are only.
This is in respect to the same accident, no?
Yes, yes, same accident. All the victims were occupants of the Maruti Gypsy.
No, postmortem also.
Yes, postmortem was refused. It was refused by the relatives of the deceased person. But for medical purpose, you were brought to Timor Civil Hospital because it is near Timor.
In other cases, you have not given evidence.
Lordship, regarding question on negligence, evidence of the claimant in MEC case number 112 of 2014 is very much relevant because this 112, 112 of 2014, this is injured claimant. Her
This is the
evidence very
injured
clear.
claimant.
Yes.
This Musangla.
Yeah, Muasangla.
Musangla is the injured claimant.
Yes, she is the only surviving victims of the accident, and she has filed this particular claim obligation, and her evidence was recorded. Lordship, paragraph 5 of the affidavit in evidence is relevant.
This evidence goes against you. We do one thing, Mr. Counsel. And you are not questioning on the compensation?
Lordship.
The
We
amount
have
of
not raised our objection before a trial court, that's why.
Now, is it done in terms with Pranay Sethi? We have a particular you see the Gauhati High Court Kohima bench portal. And there is a MACT portal there. In the MACT portal, you put these details out there and just find out. It will come out automatically how much you are entitled. So just find on that because you have not raised your two questions. One is on the ground of there being the finding is there. The finding of rash and negligent driving is there. There's a negligence on the part of the driver. And this evidence of this particular person, the Musangla, it makes it very clear because she was the only surviving, I suppose. Yes. She makes it clear. She, however, makes one statement. You should have stopped there, but you asked something else, which you shouldn't have asked. She categorically says that the accident, there were two vehicles. She should have stopped there. Then you asked again, what was your vehicle doing? It said, my vehicle was standing still. The bus hit it.
Lordship, in this particular case, the driver of the offending truck files written statement, but he declined to come to the top to deduce evidence. That is the
And your cross was on the basis of about the criminal liability or not. That is different. Criminal liability is beyond reasonable doubt whether if there was a negligence. That is not a case of negligence. It is a case of this is here one who has to also take it's a welfare legislation. Problem lies there.
Lordship, I also one ground I forgot to mention regarding this non-implementation of necessary party, the gypsy, where the deceased were traveling. I've raised this on the ground also.
You see, the claim petition, you see, there's a difference how you adjudicate the claim proceedings of this type. The non-implement should have been looked into by that court. And you should have raised that issue there about non-implement, one. But that court have looked into it and says that it makes no sense because of the fact that there was no contributory negligence. If it was a contributory negligence, it would have been different. The court says that, look here, from this evidence, it is clear that this bus came on the wrong direction, hit the vehicle which was stationary, where the driver stopped it and the vehicle hit the vehicle. So therefore, it is not required to make him a party. That is issue number one. But there is a lot of evidence being given, looked into as regards the negligence, whether it is a case of, yes, it is not so good how the trial court had framed the issues. The issues should have been better framed, but then also, should we interfere with on these two grounds? Let's take
Lordship, may kindly see one recollection.
What?
Rules of the Road Regulation 1989. This just perusal of one regulation 2 shall suffice the matter. This regulation was enforced during the relevant time. Regulation 2. If left, the driver of a motor vehicle shall drive the vehicle at the close of the left side of the road as may be expedient and shall allow all traffic which is proceeding in the opposite direction to pass on his right hand side. So admittedly, it is a case of admitted that this rule has been breached. This regulation has been breached.
Now, why are there so many appeals against the 4 cases?
Lordship, arising out of the same accident.
Hmm?
Arising out of the same accident and common judgment was passed by the same.
The common
Yes,
judgment.
common judgment. Page number 13, Your Lordship. Miss Appeal 15.
Page number?
Page number 13. 1-3. MSC Appeal 15.
No, page starts from this, Annexure 1, page 13. Yes, right. So this is the common judgment. Well, let's dictate. Let me decide now. Pass the order.
Yes, Lordship, the power is listed in this appellate court to pass any appropriate order. So, and so long as evidence is there to decide any issues that may arise during the course of the hearing, the appellate court is not, say, deprived, divulged of any powers to assume jurisdiction over the matter to decide on the question of negligence. It is to be decided side by side with issue number 1. That additional issue.
No additional issue required. We'll say that this is.
Yes, evidence is sufficient.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the appellants in the 4 appeals before the court. In the present batch of appeals before the court, Mr. So-and-so appears on behalf of the claimants. First, the present batch of 4 appeals, because is directed against the common judgment and order dated 23/1/2020, passed in MAC case number 28/2014, MAC case number 29/2014, MAC case number 30/2014, and MAC case number
112.
112/2014. The challenge made to the impugned judgment and order dated 23/1/2020 is on for 2 reasons, on 2 grounds, primarily on the 2 grounds. First, that without proving, first, the claimants have approached the court by filing application under section 166(1) of the Motor Vehicles Act 1988, for short, the Act of 1988. And therefore, it was obligatory on the part of the claimants to prove rash and negligent driving in order to be entitled to any form of compensation. The second ground is that the learned tribunal, Learned Motor Accidents Claims Tribunal, Dimapur, Nagaland, for short the Learned Tribunal, had taken into consideration a sketch map, which was neither a sketch map prepared by the police nor a sketch map prepared by way of a commission being issued by the Learned Tribunal. It was a sketch map prepared by the husband of the claimant in MSC 114/2014, 112/2014. And therefore, the learned tribunal ought not to have relied upon the said sketchman in passing the impugned judgment and order. You said another ground, no? The third?
Non-joinder of necessary parties.
The third ground on which the petitioner, the appellants submitted, the appellant raised the third ground raised by the ground of objection raised to the impugned judgment and order is that the other vehicle, that is the Maruti Gypsy, is that the owner, driver, as well as the insurance company of the Maruti Gypsy was not impleaded in the said claim proceedings. For deciding these three grounds of objection so taken in respect to the judgment and to the impugned judgment and order, this court finds it relevant to take note of the brief facts which led to the filing of the present proceedings. On 18/10/9/2013, a Maruti Gypsy bearing registration number NL032658 was proceeding from Longlang Town, Nagaland to Dimapur, Nagaland. On the way, before reaching Dimapur about 100 meters away towards Dimapur from Gautam Basti Junction on NH39, Khotkhoti, Bukajan subdivision, Karbi Anglong, Assam. On a sharp curve of the road towards the left, a bus bearing reassigned registration number AS05B6537, originally registered as NL04B/B0550, coming from the opposite direction, hit the Maruti Gypsy, which resulted in an accident. In the Maruti Gypsy, there were 4 occupants, including that owner/driver. The 3 occupants, including the owner and driver, sustained fatal injuries and accordingly expired. The legal representatives of the 3 occupants who expired have filed MAC case number 28/2014, MAC case number 29/2014, and MAC case number 30/2014. Insofar as the 4th occupant is concerned, she sustained serious injuries. And it is on that count, MAC number 112/2014 was filed. This court, for the purpose of the present proceedings, taking into account the allegations so made, taking into account the grounds of objection which were taken, this court finds it relevant to take note of the allegation contained at paragraph number 8 of the claim petition in all the claim proceedings filed before the learned tribunal. It was specifically alleged in all the claim proceedings that about 100 meters away towards Dimapur, from Gautam Bosti Junction in NH 39, Khotkoti Bukajan subdivision Karbi Anglong, Assam, in a sharp curve of the road towards the left, the bus bearing reassigned registration number AS-05B6537 PSB bus, which was originally registered as NL04B0550, owned by the respondent number 1 and was driven by the employed driver, respondent number 2, and coming from the opposite direction came by the wrong side of the road, occupying the entire road meant for the opposite coming vehicles, and hit at the Maruti Gypsy by the front right hand side of the bus. It was also mentioned that there was a road divider white paint mark all along the road. However, while negotiating the curve of the road, the bus took the road meant for the opposite coming vehicle in such a sharp curve of the road, leading to hitting at the Maruti Gypsy. The respondents, the appellants herein, who were the respondents in the said claim proceedings, have filed their written statement denying to the said allegations. The records reveal that in pursuance to the written statement filed by the respondents in the claim proceedings, as many as 4 issues were framed by the learned tribunal. The 4 issues are as hereinunder 1, 2, 3, 4, page 16 above. From the above 4 issues, it would be seen that though there was specific allegation of rash and negligence on the part of the bus, which resulted in the accident, and there was a denial to the same by the respondent, by the appellant insurance company in their written statement. But there was no specific issue framed as regards as to whether the accident which occurred on 10/9/2013 was on account of the rash and negligent driving of the bus bearing registration number AAS0182. Be that as it may, from the evidence which have been adduced by both the parties, it appears that the parties were in know that there was an allegation of rash and negligent driving, which led to the accident driving of the bus bearing registration number so and so, which led to the accident on 10/9/2013. This aspect is apparent from the various evidence so adduced by the claimants in all the 4 proceedings. And the cross-examination of the claimants by the appellant insurance company. It is pertinent to mention that though the evidence so adduced by the claimant witnesses in respect to the MAC cases number 28 oblique 2014, MAC case number 29 oblique 2014, and claimant and MAC case number 13 oblique 2014, whereby the legal representatives who were not eyewitnesses to the accident, but the evidence of the claimant in MAC case number 112 oblique 2014 is of relevance as she was the person who was injured during the accident. In her evidence, she had categorically mentioned the following as in the following in her evidence on affidavit. She categorically stated the following. Page 149 of Pabo, ha? It is how? Page 1. Following at paragraph number 5, which is reproduced herein below. Paragraph number 5 and 6. It is very pertinent to this court also finds it relevant to take note of the cross-examination of the said witness. Wherein it is seen that upon asking her asking the said witness about the accident, she categorically stated that the driver of the gypsy saw the bus was coming towards his side, but he stopped the vehicle. I cannot say whether the driver of the gypsy tried to run out of the roadside. It was also mentioned, she also stated that on cross-examination that, inverted comma, since the bus hit our vehicle, so I presume the bus had not applied the brake. The above aspect, therefore, makes it very clear that the parties, although there was no specific issue as regards rash and negligence driving of the vehicle, of the bus bearing registration number so and so is bus. However, the parties therein were were aware and accordingly evidence were also adduced and cross-examination was also carried out in that regard. In that view of the matter, it is therefore the opinion of this court. This court also finds it very relevant to take note of the decision of the learned tribunal in respect to issue number 1 and issue number 3. Wherein it was categorically mentioned wherein there was findings of fact arrived at on the basis of evidence that the bus in question that the mounted gypsy stopped the vehicle when he saw the bus coming. And the mounted gypsy could not go to the left side of the road as there was a steep cliff there. It was also the finding of fact that after the gypsy had stopped the bus, the bus came with high speed and hit it. The evidence, the findings were arrived at being based upon not only the findings were arrived at by the learned tribunal, not only discusses on the issue of rash and negligent driving, which resulted into the accident on 10/9/2013. But it is also a finding based on the materials of report, and no perversity in that regard could be shown. This court at this stage also finds it relevant to take note of that in exercise of the powers conferred by Section 18 of the Motor Vehicles Act 1988, the central government had made a set of regulations known as the Rules of Road Regulations 1989. Regulation 2 is relevant for the purpose of the instant case in as much as it stipulates that the driver of a motor vehicle shall drive the vehicle at close to the left side of the road as may be expedient and shall allow all traffic which is proceeding in the opposite side to pass on the right hand side. Taking into account the above, this court is of the opinion that the first ground of objection so taken in respect to the said member to the impugned judgment and order dated so and so cannot be sustained in law. Next. The second ground of objection so taken is that the learned trial court, the tribunal had relied upon a sketch map in the impugned judgment. This court finds it very pertinent to take note of that a perusal of the impugned judgment is not solely based upon the said sketch map, but specifically relies upon the eyewitness who was present, that is the claimant, in MSC case number 112/2014, evidence of the claimant in MSC case number 114/2014. Under such circumstances, merely taking into consideration an evidence which is being placed cannot be a ground to nullify the said judgment. The third ground of objection which has been taken is on the question of not impleading. The owner oblique driver of the Maruti Gypsy, which was involved in the said accident. It is relevant to take note of that the owner oblique driver of the Maruti Gypsy was one of the persons who had expired. He died. Had expired on account of the said accident.
There is no proof that he was the owner of the Maruti Gypsy. Yes, but documents, no documents was placed before the tribunal.
No, this is what is being mentioned.
The owner driver of the Maruti Gypsy also died in the accident.
This is what it is stated here.
So his legal representative has filed one claim application here against the past.
Now you see, what is the name of the owner driver who died?
The owner driver who died in the accident is one.
The MSC case number?
It is in.
He also filed the application, huh?
Yes.
But Your Lordship, there is not such documents to prove that he was the owner of the Gypsy. That must be foundation.
But which is the application filed by him?
The application filed. The legal representative of the deceased driver is MSC case number 30 of 2014.
What was the name of the driver?
The name of the driver is one Ning Sankaba.
Huh?
Ning Sankaba.
Ning Song? No, his MSC case number is
29.
Huh?
29.
Right. The name of the disease is one Nitong Pom.
That is MSC 30 of 2014.
MSC 30. Nitong Pom is the owner driver of the gypsy,
30, nah?
30, Your Lordship.
30.
It can't be him. It can't be him. Who has filed this application?
The application was filed by the father, mother, and siblings, brothers and sisters, all minors. There are altogether 9 claimants in this case.
Here it is mentioned. Let us see his written statement. No, you have not denied that. It is the case of the petition. It is relevant to take note of that the owner, oblique driver of the vehicle of the gypsy bearing registration number had also expired in the said accident. In the fatal accident, expired in the accident dated 10/9/2013. And his legal representatives filed the claim petition being MSC case number 30/2013, 30.
2014.
MSC case number 30/2014. At paragraph number 8 of the said application, claim application, it was categorically mentioned that the deceased was the owner oblique driver of the Maruti Gypsy. And the applicant claimants were the legal representatives of the said deceased. The writ petition, the affidavit, the written statement filed by the respondents who are the appellants herein have not denied the said aspect. Be that as it may, the learned tribunal had categorically looked into have categorically took up the said issue as issue number 1 and held that as the gypsy and held that there was no contributory negligence on the part of the gypsy, requiring the gypsy to be made a party. Nothing has been shown before this court that the said findings in respect to the issue number 1 is perverse and is not based upon evidence. Considering the above, it is the opinion of this court that the 3 grounds of objections which have been taken to the impugned judgment and decree, judgment and order dated so and so, passed in MSC case number so and so, so and so, so and so, cannot be sustained in law. Accordingly, This court does not find a merit in the instant appeals. The merit, the writ appeals accordingly stands dismissed. The records, the learned, the registry shall forthwith return the records back to the learned trial court. So the interim orders which have been passed earlier stand vacated. The respondents shall be the appellants are directed to make stands dismissed, records be returned. I think that will be enough. Then they will. Yes, Mr. Joe.
My lord, my senior all of everything item 23. Next item tomorrow. Next item.
What is that matter?
We're challenging the order of law at the challenging the order passed by law on the ground it's in violation of the act.
Mr. TV Jamil, you were looked at. Okay. And there was one matter which I was fixed today for the purpose of the passing the order, isn't it?
Supplementary.
That nobody gave me this here, WPC number 129, the tax matter. Who is there?
My lords, I am appearing. My senior is also there online.
Where?
Once.
Yes,
Oh,
Lordship.
madam, you are back to Delhi.
Calcutta, yes, sir. Yes,
Madam,
Lordship.
we'll do one thing.
Yes.
They didn't call up. I'll pass the order. We'll get it today itself, but tomorrow. The order is that I direct this I set aside these two orders of 17.7 and 18.7 and direct them to issue notice if they deem so as per section 74. And in doing so, one thing I have to say that taking into account that these matters have been, you have not prepared an appeal and have directly approached this court under 226, this court, the period within which the instant writ petition has been pending shall be excluded while computing the period of limitation in terms with 73.9 or 74.9 as the case may be. That's the order.
Lordship, may kindly also record that the payments which were made under DRC 03 were under protest and not voluntary. And DRC 04 also not issued by them.
No, wait. I have recorded paragraph number 7 in my order that day. Be that as it may, it is alleged that the petitioner number 2, by petition number 2, that as the respondents indulge in taking coercive steps, the petitioner number 2, under compelling circumstances, had to make certain payments. That is your statement which is there. So therefore, I'll just pass that order. I'll go on because here nobody.
Lordship, liberty to challenge the new notice on other grounds available if required.
That is already there.
Yes, Lordship.
That is already there. We always need to have you here.
Yes,
Obliged. May I mention one matter, Lordship? I'm appearing online.
Okay, I'll put Mr. V. Jimomi's over. Yes.
Correspondent number 1.
For respondent number? Earlier, Mr. Longkumar was appearing. You want to oust him? Huh? Mr. V. Jimomi. We'll get the order, and the other is you were appearing. No? Yes. You kindly give your names, they will keep it. Huh? We'll pass this order. Today it will be shown as disposed. Huh? These two matters. It is there listed today.
Yes.
Item numbers? These are disposed. Yes. You want the matter to be taken up tomorrow?
Yes.
Okay.
I mention one matter, Lordship.
Yes, what is that?
Item number 24, my lord. There is a stay operating against me. I'm for the respondent. So I'm requesting if your lordship can take it up tomorrow or day after tomorrow.
No, no time, day after. 24.
My lord, if my lord may see, it's a very small issue. It's regarding probate testamentary appeal. Now, in the entire appeal, without evidence, nothing, they have filed like a writ petition. So lordship will, if lordship gives a look into the matter, I think lordship, because so they have annexed all the documents without any making it an exhibit of civil code.
It won't be possible for me to take it up. You see, the problem is Tomorrow I'm there. How many matters are there? You never know of it.
I understand, Lordship.
List, yeah. How many matters are there? Already I'm fixing Mr. TB Jami's matter tomorrow.
Yes.
And there are two other matters also tomorrow. Let's see, but I don't think this is possible to pick it up.
Wednesday, my lord.
Another matter, another first appeal to
Yes,
dispose.
I've seen it. I was there. I've seen it.
So let us.
Wednesday, my lord. Keep
Okay,
it
we have it on 30. Let's fix it on 30.
I'm sorry, my lord. My lord, not on 30th, my lord.
Okay, the 31st, first?
First of April.
At the request of the Learned Council for the respondent, the matter stands adjourned to be listed on 1st of April 2026.
Highly obliged.
Number 3 is interim. Item
It
number
is
3.
to be fixed tomorrow.
Yes, Lord.
Is the matter tomorrow? Interim order passed earlier shall continue until the next date. Sure.
Highly obliged.
What is listed?
24, I fixed it, na? Tomorrow? Very good.
First.
1st of April, my lord. 24th, Lordship has fixed it on 1st of April.
24, I'm fixing it on 1st of April. Okay. That is what you are appearing, na? He's there, na?
Yes, I'm assisting him.
Okay, you. And the other side, somebody is there. Mr. Pongsik Pote. Okay.
Obliged.
Anything?
25.
Item number 25, my lord. If it can be fixed on 2nd of April, my lord.
Chalo, on 2nd of April.
That's it.
Oh, 1st of April, not possible. It is a Wednesday. It will be on 2nd of April. I forgot here.
Lordship. As your lordship.